Beautiful friends, it is an amazing Monday. We are going to wait for those tubes to fire up all across the fruited plain of the interwebs before we get started. We got some serious business fresh out of the oven this bright and early Monday morning. We're going to go through it. It is about 93 pages of goodness coming from Judge Eileen Canon. Florida classified documents case was dismissed. We are very excited about this as we've been covering it for a long time. And so I want to get right into it. Let me share with you exactly what has happened. Judge Eileen Canon dismisses the classified documents case. Woo! This is a good one. Excited to see it here. I want to start with just the final portion of the opinion, the order here. Then we're going to go through it in full after we see some reaction because there are meltdowns already taking place. We have Adam Schiff is crying from the rooftop. We don't even know what Jack Smith has said yet. Trump has a statement out. So does Thomas Massie and many others. But we're going to go through this full opinion because this is the end of the classified documents case. It's done. Watch this. Here, for the reasons set forth above, this is Judge Eileen Canon presiding over this. Writes this right now. This is now ordered and adjudged as follows. Woo! Trump's motion to dismiss the superseding indictment based on the unlawful appointment and funding of special counsel, Jack Smith is hereby granted. Oh, what does that mean? The superseding indictment is dismissed. Bye-bye, case is gone. Sorry, Jack. You lose the whole case. God. Oh, the order shall not affect or weaken any of the protections for the classified information imposed in this case or any protective orders pertaining to the classified information. So all of that's still going to be under lock and key. But the clerk is directed, watch, to close this case. Oh, Jack Smith blown out. Oh. Any scheduled hearings are canceled, any pending motions are denied as moot, and any pending deadlines are terminated. Just like you, Jack. Done and ordered in chambers at Fort Pierce, Florida, this 15th day of July 2024. So Jack Smith is done, not allowed to move forward in this case. The clerk is directed to close this case. And it only is confined to this proceeding. This court decides no other legal rights or claims. So Trump will turn around and say, oh, well, that's interesting because Jack Smith is also the special counsel in the January 6th case. Oh, in Judge Chutkan's courtroom. And so if that is true, if he is also the special counsel there and he's not lawfully appointed here, then he's not lawfully appointed there. Now, this case is not going to be binding on Judge Chutkan. Judge Chutkan could have a totally different opinion and will. And so this will obviously cause a circuit split. And so we'll have the D.C. Circuit versus the 11th Circuit going up to the Supreme Court. And so this case is likely going to go to the Supreme Court. This issue will likely arrive there at some point because Trump will make the same parallel argument with Judge Chutkan. She, of course, is going to deny that. She's going to say Jack Smith is absolutely lawful and appropriately appointed. But Canon says no, and Canon is basing this off of in part, in the concurrence from the Trump case that came down from the Supreme Court. Justice Clarence Thomas was out here explaining that Jack Smith was not lawfully appointed. And not only that, Jack Smith was illegally appropriated. So he was taking money that was not his from the Department of Justice, from their Get Trump slush fund. This is tremendous news. This is going to be absolutely devastating to the government's case. Not obviously in this case, it's done. They're done. They're going to appeal this, no doubt about it. But we'll see where that one goes because this is not a jury verdict or anything. So I'm sure that Jack Smith will be already discussing an appeal. But I want to go through this entirely. Okay, there's about 94 pages, 93 pages you can see here. We're going to go through it. Before we do, let's hit some of this reaction just so we can see the magnitude of this ruling. Trump came out, he posted this. He says, as we move forward in uniting our nation after the horrific events on Saturday, the dismissal of the lawless indictment in Florida should be just the first step, followed by the dismissal of all the witch hunts. Now, this case, as I said, will be persuasive to the January 6th hoax in Washington. but not binding. And it will really have no other relevance to any of these other state level claims because Jack Smith is only prosecuting the 2 federal claims. But Trump is right about this. Now, the immunity decision plus Jack Smith's unlawfulness are showing us clearly that all of these were political prosecutions. There was no basis for Jack Smith to even exist. He's not a U.S. attorney, was never appointed by the president, was never confirmed by the Senate, was illegal from the very beginning, and they prosecuted Trump anyways. Same thing with the DA Zombie case from Manhattan. Trump had immunity. Trump layered in immunity. He objected based on immunity during the trial, and he was overruled. Judge Merchan just allowed the case to go forward. And now Trump is saying, you brought in evidence of my Oval Office conversations and my team, my employees were all part of the case. They were all testifying. We had Hope Hicks, White House Communications Director. We had Madeleine Westerhout, Oval Office Operations Director, all testifying, all Oval Office immunity stuff. So Trump continues. He talks about the New York AG scam, fake claims about a woman I never met, a decades-old photo in a line with her and her husband does not count, talking about E. Jean Carroll, Bergdorf getting Bergdorfed into Bergdorfs, and the Georgia perfect phone call charges, which is Fannie's case. The Democrat Justice Department coordinated all of these political attacks. That's true, which are an election interference conspiracy on their own against Joe Biden's political opponent, me. Let us come together to end all weaponization of our justice system and make America great again. And so Trump was out. We had other reaction from Thomas Massie. He says, last month I questioned Attorney General Garland about the constitutionality of Jack Smith's appointment. He did not have good answers, and we remember that exchange. He says, fast forward to today, Judge Canon just dismissed the classified documents case against Trump, citing the unconstitutionality of Jack Smith's appointment because he is illegal. And we've read basically every single motion that has been on this case. And can we just say shout out and major congratulations to Ed Meese and Calabresi and the law professors and everybody else who submitted the amicus briefs on this issue. This was fought and fought and fought, and it made the most logical sense. What the government was trying to claim by cobbling together all their statutes that gave them power was obviously insane. So now justice has been done. Adam Schiff is very upset about this. He says, today's precedent-shattering decision in Florida is further proof that the guardrails of our democracy are coming down. It's like you guys are whacked. You know who knocked those guardrails over? You guys, when you indicted Trump in the first place with an illegal special counsel for charges that are fake. They were his documents, and other people who've had the classified documents problems who were never the president, like Hillary, like Pence, like Senator Joe Biden, like VP Joe Biden, no charges for them. So guardrails of our democracy just means they're never-ending power. Just substitute democratic power every time you hear democracy. The guardrails of our democratic power are coming down. That's true. That is true. Because your Democratic Party is now being shown for what they are. Again, a partisan judge throws out decades of precedent, which was all, by the way, this was all very complex precedent, okay? The statutes that they used to create the special counsel may work for somebody who is an actually U.S. attorney of the government, right? Somebody who is appointed by the president, confirmed by the Senate. So it applies to somebody who is, it's actually not, we'll read the opinion, but he says to reach a desired political outcome, which is hilarious because that's all they're doing. He says justice is again delayed, so it may be denied. And Adam Schiff, I don't think he has it in his X profile, but just let us not forget that this guy got censured like a total loser for being a liar about basically everything. So represents California's 30th district. I think he wants to be a senator now, but he didn't include in his little bio there that he's been censured because he doesn't want you to know about that. Ben Garrison went very quickly. I don't know how he does it so quickly, but our friends over on Locals shared this one this morning. This is Jack Smith's worst nightmare. And I don't know if this is new or if he had already prognosticated this, but case dismissed. Trump comes in with pizza for everyone. What a nice guy, man. Trump. Jack Smith having a bad Monday morning, that's for sure. They had all their eggs in the Jack Smith basket. Fannie's totally blown out of the water. We've got sentencing, which is now delayed for the Alvin Bragg case. So we're going to see what happens with the Jack Smith case in Judge Chutkan's courtroom, but that's got to come back down for immunity decisions and evidentiary hearings. And so Jack Smith is just having a bad day because he's a terrible person and deserves it. Here's one from Jonathan Turley. Says the dismissal of the classified documents case is a seismic development. No doubt. From the beginning of all these cases, I've said that the Mar-a-Lago case was the greatest threat to the former president. It is now gone. Gone. It's huge. It's absolutely huge. And we were a little concerned. I think your boy here may even have said that I don't think Cannon's going to do this. Pretty sure I said that. This was a big deal. This is a big move, and it's absolutely the right decision. We've read through every single amicus brief from Ed Meese and the other individuals, and it's the right decision. We're going to read it here in a second, but I wanted to share some reaction. Here is how MSNBC was reporting it this morning. Let's see if they're happy about this. But this was their news.
Breaking news on the classified documents case. Let's get right to Ken Delanian. Ken.
What's the latest, Ken?
Jose, in a remarkable development, Judge Eileen Canon in Florida has dismissed the indictment against Donald Trump in this classified documents case and his co-defendants on the grounds that the appointment of the special counsel violated the Appointments Clause of the Constitution. This is an issue that has been litigated in other special counsels, has never succeeded, but Judge Eileen Canon has accepted the arguments of the defense that the appointment of Jack Smith and other special counsels, by inference, has been improper and illegal. And I'll just read you briefly from the opinion here. She says the bottom line is this: the Appointments Clause is a critical constitutional restriction stemming from the separation of powers, and it gives to Congress a considered role in determining the propriety of vesting appointment power for inferior officers. The government's position, she says, effectively usurps that important legislative authority, transferring it to a head of department. Let me translate that.
Yeah, we'll go through the whole thing. I thought that maybe they were going to give us some opinion here, but looks like maybe not. So Alina Abba also came out, says, the unlawful appointment and funding of special counsel Jack Smith has been a critical factor of the sham documents case. This dismissal marks the first step in ending the weaponization of our justice system, restoring the rule of law, and making America great again. Yeah, Jack Smith, if they really wanted to go after Trump, they could have just appointed a special counsel who was a U.S. attorney. That would have been interesting of them to do that. Now, we know that they know how to do that because they've done that before. So remember when Joe Biden ordered Merrick Garland to go after Trump, Merrick Garland came out and appointed Jack Smith to prosecute Trump. Jack Smith was not appointed by the Senate, appointed by the president or confirmed by the Senate. But then when Joe Biden had his classified documents, guess what happened? Merrick Garland came out and appointed Robert Hur. Remember Robert Hur? So Robert Hur, as we know, is an actual United States attorney for the District of Maryland. Isn't that interesting? So Robert Hur was appointed by the president, was confirmed by the Senate. So Jack Smith, who was not appropriate. And as we know, as we can see here, the DOJ knows how to select U.S. attorneys to be special counsels. So it's nothing out of the ordinary. They know how to do it. They just chose to pick Jack Smith because he is their hatchet man, and they're very excited about him doing their bidding. It worked out well for him until it didn't. Now they have lost. And so let's take a look at the opinion itself. You can see we have got some fun stuff to attend to here. And so let's get right to it. We have 93 pages of deliciousness that we're going to go through here to see how this all works. In the classified documents case, Judge Eileen Canon presiding, now ordering and granting Donald Trump's motion to dismiss the superseding indictment based on the Appointments Clause violation. Here's what Canon says. All right, former President Trump's motion to dismiss this whole case because Jack's illegal is hereby granted. The indictment is dismissed because Jack Smith and his appointment violates the Appointments Clause of the United States Constitution. Saying Jack Smith's use of a permanent indefinite appropriation also violates the Appropriations Clause. And But the court doesn't need to address that. The proper remedy for that funding violation, given that the dismissal is on the Appointments Clause grounds. So we're not really going to talk about Jack Smith's illegal funding, or we don't need to address that because she's going to hang her hat on the Appointments Clause, saying the motion before the court challenges the legality of Jack Smith. So Trump submitted this. Two consequential aspects, both of which are matters of first impression. So first time we're actually hearing about any of this. And both of which must be resolved before this prosecution can continue. Now, the first is a challenge to Jack Smith's appointment under the Appointments Clause. We already know the Appointments Clause, Article 2, Section 2. It says a rule. If you're going to be an officer of the United States, whether you're an inferior or a principal officer, you have to be appointed by the president. Okay, it's in the Constitution. If you're going to be an officer of any kind, appointed by the president, confirmed by the Senate. Those are the rules. It then goes on to direct that Congress may by law vest the appointment of the inferior officers in the president alone, in the courts, or in the heads of the department, right? So the Constitution gives us a base layer rules. And they say Congress can change those rules, but it's very specific. They can only give it to the president, heads of departments, or the law. And for the purposes of this order, the court accepts that Jack Smith's contested view, right? Jack Smith says he's an inferior officer, not a principal one. So she's even giving him the benefit of the doubt here, which is wild, because he's clearly a principal officer. He's not an inferior officer at all. Jack Smith has basically unfettered power to go prosecute the former president. It's insane. And they said that he's not really managed by Merrick Garland, but then he kind of is, right? He's a special counsel, so he's independent. So he's not under Merrick Garland, who is under Joe Biden, which would make it Joe Biden's prosecution. So they say he's not really under him. And if he's not under him, then he would be an absolute principal officer, right? Because he's basically, no one's in charge of him. Now, although the court expresses reservations about that, because it's obviously false, we're going to address those below. But even if we give him the benefit of the doubt and say he is an inferior officer, which he's not, then he still loses. The motion's second challenge is rooted in the Appropriations Clause, which is about money. And you can't get money unless you're appropriately appointed. So both of these appointments and appropriations challenges are framed in the motion. They raise the question. Here's the question, the big threshold question that's going to decide everything. Is there a statute, is there a law in the United States Code that authorizes the appointment of a special counsel, Jack Smith, to conduct this prosecution? And it's about Jack Smith, again, who was never lawfully appointed or confirmed. After careful study of this seminal issue, Judge Canon says the answer is no. Sorry, Jack, you lose. None of the statutes cited by the government as legal authority for the appointment gives the Attorney General broad inferior officer appointing power or gives Merrick Garland the right to appoint a federal officer with this kind of power, nor do special counsel's statutory arguments, appeals to inconsistent history, or reliance on out-of-circuit authority persuade otherwise. So Jack loses. The bottom line is this, says Judge Canon. The Appointments Clause is a critical Constitution restriction and constitutional restriction stemming from the separation of powers. And it gives Congress a considered role in determining the propriety of vesting appointment power for inferior officers. The Constitution gives that power to Congress. Jack's position usurps that important legislative authority. The executive branch can appoint their own prosecutors and fund them indefinitely. They now transferred it to a head of a department, and in the process, they threaten the structural liberty inherent in the separation of powers. If the political branches wish to grant the Attorney General the power to appoint Jack Smith to investigate and prosecute this with the full powers of U.S. Attorney powers, then there is valid means to do so. All you have to do is appoint him. All you have to do is confirm him through the default method prescribed in the Constitution. Congress has already done that for tons of other U.S. attorneys. We saw it with Robert Hur. They can do it. Merrick Garland can do it. He knows how. Or Congress can authorize his appointment through enactment of a positive statutory law consistent with the Appointments Clause. So Congress then can pass a statute like they did with the Independent Counsel, which is no longer existing, but they did this before. So here's what Judge Canon says in her order. It proceeds as follows. After laying forth the pertinent factual procedural background leading to the present motion, the court summarizes the legal principles underlying. The court then surveys the structure, and following all of that, we'll get to some more answers. And so let's take a look at the history. So on June 8th, 2023, we remember, a grand jury came back with an indictment. Jack Smith signed it. Trump got charged with different charges. 31 counts of willful retention of national security information. Also charged two other people, Walt Nada and another gentleman. Now, on July 27th, the grand jury came back with a superseding indictment. There they added Carlos de Oliveira. On February 22nd, Trump filed this motion. We had a bunch of people file amicus briefs. Remember, Landmark Legal, constitutional lawyers, Ed Meese, many others. And the court later ordered supplemental briefing. Then we heard lengthy oral arguments just in June. Now, the motion seeks to dismiss the case. They say Jack Smith himself, Jack Smith specifically, was not nominated by Biden. He was not confirmed by the Senate, as would be required of a principal officer or an inferior officer. And Congress hasn't passed any laws to appoint him. And two, even accepting the position that he is inferior, none of the statutes cited vests Merrick Garland with the authority to appoint a special counsel with the full power to investigate and prosecute whatever they want. Jack Smith has that power. So you basically made him a U.S. attorney without actually making him a U.S. attorney. That's illegal. The motion separately raises a money challenge under the Appropriations Clause because this is wild, just so we know this exists in our DOJ. He is drawing on so they have a permanent indefinite appropriation that's reserved for independent counsel, which doesn't exist anymore. That doesn't apply to him. And so there is no other law authorizing the appropriation as to him. So they were stealing a bunch of money as well that was already earmarked for independent counsel. So our corrupt DOJ, which is supposed to be tasked with the duty of upholding the law and fairly interpreting the law, was stealing a bunch of money from the independent counsel bank account and then using an illegal prosecutor to go after their political opponent. The special counsel opposes both challenges. He says, as to appointment, he says, no, we are lawful. He cites the Nixon case. But as to the appropriations, he also says that he lawfully draws from the indefinite appropriation because he's like, I'm pretty much an independent counsel. He says, I still retain substantial independence from Merrick Garland, which again, it's logically inconsistent because if he still retains substantial independence, then that makes him a principal officer because he's independent. And he was appointed pursuant to the other law, right? They took all these other statutes and cobbled them together and said, well, we can kind of fit it in here. In any case, Jack Smith says all of these were lawful and he should have his money and his appointment. For some factual background, Judge Canon walks us through how this all started. On November 18, 2022, Merrick Garland appointed John L. Smith, an attorney from outside the U.S. government. Jack Smith is not a U.S. attorney, to serve as special counsel for the Department of Justice. What's interesting is Jack Smith was not nominated by the president and he was not confirmed by the Senate. So in the order, Attorney General Garland, they said, the order states that Garland is, quote, vested, wherever that comes from, with appointment power. And he can do this. And how did they come up with this power? They said, well, Congress did pass some laws. 28 U.S. Code 509, 510, 15, and 33. And the judge is going to walk us through all of these. But the appointments order then authorizes Jack Smith to conduct 2 investigations and to prosecute those crimes. The first, of course, is the J6 case. The second is the classified documents case. Now, with respect to the funding, Jack says that we can use this permanent fund, slush fund, to pay for our needs. This is a limitless appropriation. There's no end of it. It's just a slush fund for the DOJ. As of September 2023, Jack Smith has spent $12 million, okay? So Trump has to defend this, right? This is the government. So they've used almost $13 million. And watch this. He's also dropped another $11 million in component expenses that are attributable to this investigation. So Jack Smith has dropped about $24 million on this prosecution. All right. That's government money. That's our money. We paid for that. So our DOJ is using a slush fund that comes from our funds as taxpayers to prosecute a candidate in our election season. It's sick. And Trump has to respond on this. Okay, so like these are just government lawyers, probably hundreds of people working on this case with different contractors and different agencies. Trump has to respond. So Trump has to come up with his $24 million to respond to that. And it's probably a lot more than that, right? Because the government already has infrastructure in place. It costs a lot more for the defense to stand up a defense than it costs for the government to stand up a prosecution. They already have full-time prosecutions. And these prosecutors and these people on this case are basically working on one case. That's it. It's their whole life. Jay Bratt has nothing else ever that he gets excited about other than Trump's prosecution. So Trump then gets charged. He has to stand up a defense team. It's much more disruptive to the defendant. So Trump might have to come out of pocket $50 million, right, in order to respond to the 25. That's a 2-to-1. What if it's a 3-to-1? That is opportunity cost. That's opportunity money, opportunity time that Trump could be spending elsewhere, reinvesting back in to the campaign season. And so this is the government just shackling him with lawfare. It's sick and it's unlimited. Now, at the end of the appointment order from Merrick Garland, which was totally fake, there is the following reference to the Department of Justice regulations. So just to be clear on how this works, okay, we have, let's say the highest law in the land is here, okay, we'll call that the Constitution. Constitution says we got to do certain things. And in order to have someone like Jack Smith, we've got to have Congress pass some statutes. So we'll call this Congress. Okay, so the Constitution's up at the top, then Congress is governed by the Constitution, and then Congress has the obligation and the power to create some law, right? Some statutes. So then they will pass the statutes. And the statutes are what we referenced up here, U.S. Code Section 591. So we have the Constitution. You heard us talk about Article 2, Article 3, Article 1, Section whatever. Okay, these are all the Constitution says Congress operates this way. Those are the rules for Congress. Then Congress passes the statutes. And then even below that, once we have the statutes, then we have what are called the regulations. So then we go down and we see the statutes will need interpretation because Congress is just filled with idiots. And so they write really bad statutes. So then the different agencies create regulations. And you probably have heard of these, the Code of Federal Regulations, often referenced as CFR. So you hear U.S. Code all the time, U.S. Code, USC. The CFR is the Code of Federal Regulations. So then they have regulations, and these regulations are often written by the agencies, which are interpreting the statutes. So you see how you can have this little game of telephone where things get perverted in the process. So the regulations then, right? So then the DOJ takes these statutes, which don't give them any power at all, and they write regulations that do give them power. So then those regulations are referred to Jack's regulations. They're enforced today, and they stem from a rule from Janet Reno in 1999. The notice of the final rule states that the regulations, okay, so the regulations replace the procedures for the statute. So Congress had a statute right here for independent counsel, and that authorized the independent counsel, and it authorized the money that Jack Smith was getting. An independent counsel would have gotten. But then Congress realized that this was a really bad law. So they deleted this. And so there really was no statute anymore. And so what they did at the DOJ is they said, well, there really is no statute, but we really want that stuff. So they just wrote new regulations. They just wrote a whole new set of regulations, and they call them the Reno regulations. It consists of 10 sections spanning various topics ranging from a bunch of different things, okay? So you've got jurisdiction, power, staffing, conduct, accountability, a bunch of other things. And they call it 28 Code of Federal Regulations 600.1 to 6.10. 600.10. Now, as most relevant here and more fully explored below, the special counsel regulations just created, okay, it's not Congress who did it. Congress didn't write these regulations at all. Congress got rid of the statute, and so they just made up their regulations. And here's what they gave themselves the power to do. declare the grounds for appointing special counsel from outside the government. Just made that up. It's not in the law. There's no congressional law for that. Directed the Attorney General to establish the special jurisdiction of the special counsel. Authorized the special counsel to investigate and prosecute whatever the hell they want, right? Not this, and you see every one of these is referencing the 600.6. That's the CFR. That's the Code of Federal Regulations. Also, that the Attorney General can remove the special counsel. The special counsel has discretion to consult with the Attorney General. All of these things, they just made up out of whole cloth. There's no basis for it at all. Now, distilled down for present purposes, Judge Canon says, look, the special counsel regulations mandate that the special counsel be selected from outside the department, and then they empower that outside attorney to exercise all investigative and prosecutorial functions of a U.S. attorney. It's like, wow, okay. So they can just bring in their own special people to do what a U.S. attorney does, but we have rules on how we get U.S. attorneys. And Congress didn't give you any of these powers at all. Now, prior to the promulgation of these special counsel regulations, from 1978 through 1999, there was a statute, right? I explained that before. That statute is now expired. And we used to have a 3-judge panel. We used to have an independent counsel. And there was a big case about this. The legality of the independent counsel was brought up in a Supreme Court case in 1988, talking about the Appointments Clause and other things. Now, Congress let the Independent Counsel Act expire, never reauthorized it. But Janet Reno opposed the reauthorization, and she criticized the act. And so she then created her own. So the special counsel regulations have remained in place without change ever since. No such special counsel exists today like an independent counsel at all. And no such statute existed in November when Merrick Garland appointed Jack Smith. So let's talk about how this works. Article 2, Section 2, Clause 2 of the Constitution says that the president shall have the power by the advice and the consent of the Senate to make treaties. And the president shall appoint all other officers of the United States whose appointments are not already provided for and which shall be established by law. So the president can appoint the officers if the Constitution declares it or if Congress passes the law. But Congress may also, by law, which is by statute, meaning they would have to pass a U.S. code, they may vest the appointment of those inferior officers as they think proper in the president alone or in the courts or in the heads of the departments. Very clear rules. Tells us how it works. Now, the appointment clause establishes 2 types of officers, principal or inferior officers. Principal officers must come with the advice and the consent of the Senate. The mechanism is the default manner of appointment. But we can also do other things. The clause says that Congress, by law, may, as it thinks proper, vest the appointment of the inferior officers, okay, so not the principals, in 3 places and only 3 places. President can vest, courts can vest, or the heads of the department can vest. So for our purposes, that would be like Merrick Garland. But any decision to dispense with the presidential appointment is Congress's to make, not the president's. And the president can't delegate that down to Merrick Garland, who then can appoint Jack Smith. The framers considered, very importantly, and they maintained a proposal, they considered and initially maintained a proposal where the president alone would have had the authority to appoint officers. But it was replaced in 1787 because they wanted to increase the scope of that power. Now, the Appointments Clause is more than a matter of etiquette or protocol, okay? It is among the most significant structural safeguards in the constitutional scheme because we don't want the president to just appoint his own people because that's what the king had in England. We were very sick of that because the bureaucracy just got bloated. We want some other checks and balances in this. It's rooted in the separation of powers. It's fundamental to our system of government. We do not want one branch of government like Joe Biden's aggrandizing itself at the expense of another. The Appointments Clause also preserves the Constitution and the structure of the Constitution. But if we put this another way, there can be no expansion of the vesting power beyond what is permitted in the clause. Just because Janet Reno created some regulations doesn't mean you can usurp this power. It must be strictly construed. Here's what we have learned so far, says Judge Canon. She says, let's pause. I know she's like, I've been talking a lot here, so let's just summarize this. The Appointments Clause reflects a carefully crafted system, separation of powers, and the executive and the legislative branches jointly participate in the appointments, and each side limits each other. That way we have public accountability, and the executive branch can't appoint their own prosecutors to prosecute their political opponents. Congress retains a pivotal role in the appointment sphere, a role that cannot be usurped or expanded, which they've done here, by trying to take it away from them and give it back to the Attorney General. And the Appointments Clause imposes a mandatory and exclusive procedure that must be enforced according to its plain meaning without exception. Now, we need a clear statement rule. Trump appears to agree with these arguments that there needs to be a delineation of who is doing what, where they came from, talking about Jack Smith. And so as we continue, we'll fast forward through some of this clear statement stuff. Let's see how Jack Smith was appointed. Now, before delving into particular statutes, because the DOJ and Jack Smith say that they can cobble all of these various statutes together and then they can take their power from that. Before we do that, though, says the judge, the court wants to survey the structure of the DOJ. Why do they think that they're authorized to appoint people like this? Jack Smith, well, the DOJ operates under Title 28. In Chapter 31, Congress requires the president to appoint, with the advice and consent of the Senate, the AG. Congress then provides the president to appoint various officers, all of which are expressly by and with the advice and consent of the Senate. That's the AG too. The deputy AG gets appointed with advice and consent. So does the associate AG. So does the solicitor general. And the 11 assistant AGs do too. In each of these statutes, Congress employs language tracking the default manner of appointing principal officers. It's the same. By contrast, in a separate section, Congress also permits the Attorney General to appoint non-officer employees to the agency. We also know about the FBI, right? The FBI is headed by a director, also appointed by the president. Chapter 35, which they reference, talks about U.S. attorneys. Directs the president, again, to appoint by and with advice and consent of the Senate a U.S. attorney. So we have advice and consent repeatedly. All 93 U.S. attorneys currently have been appointed and confirmed this way. Now, interim U.S. attorneys can have specific restrictions on them, but they can be permitted without appointment by the president and confirmation by the Senate, but they're interim. Limited duration, and so on. Now, it also bears noting that U.S. Code 54328 says, allows the Attorney General to appoint attorneys to assist U.S. attorneys when public interest so requires, including the appointment of tribal prosecutors. Now, he doesn't, and he disavows any notion that he is assisting a U.S. attorney. So Jack Smith is not relying on that. Now, there is one last piece, says Canon, where there is some appointment authority. It's in Title 18, which is talking about prisons. So that doesn't apply here. So she says, all right, now let's talk about what they say they do have authority to do. Canon tells us, all right, Jack Smith has 4 reasons why he says he can be on this case. But the court concludes that after reviewing all 4 of them, 509, 10, 15, and 33, that none of them give Jack Smith any power to do this. He is replacing the role of a U.S. attorney within his jurisdiction. He is not assisting a U.S. attorney. He is the U.S. attorney, and he's not allowed to do that. So the court begins its analysis. And the judge says, here's how I'm going to read this stuff, okay? I'm just going to read it according to its ordinary meaning, and I'm going to read it in context. I want to see what chapter it's in. Because is this about prisons? Is this about the FBI? What is this about? I have to put it in context. and says, let's do it. So when we talk about U.S. Code 509, here's what Jack Smith says. He says, well, no, I mean, I have power under 509. But she says, no, you don't. It's a generic provision. All it talks about is functions of the Attorney General. That's all. Now, Jack Smith doesn't say that 509 creates an office, which he would need, nor that it grants any officer appointing power to the AG. In fact, it doesn't do any of those things. It's a general statute simply declaring that the Attorney General does things. No more discussion about this section is even needed. It's basic. It says all functions of the DOJ go to the AG, and it includes these things. Nothing in this law, which is U.S. Code, okay, this is not a regulation. This is something Congress passed with the power of the Constitution behind them. Nothing in it says anything about a special counsel or Jack Smith. So they turn now then to 510. And they say, okay, well, we have also power under 510. No, you don't. This is also a general provision. It says the AG may from time to time make such provisions as he considers appropriate, authorizing the performance by any other officer or employer agency of the DOJ, right? So she puts that in italics. So they have to actually work there. Now, Jack Smith does not classify or rely on this as officer appointing or office creating, because it doesn't. Does this create an office for you? No. Did this appoint you? No. So it uses similarly general phrasing as the previous section, and it says that you can do this for existing DOJ officers, not people who are outside the government. Jack, as all agree, and as required, was selected from outside the U.S. government. So we don't need to talk about 510. You have no power there either, Jack. How about the next one, 515? The third statute cited by Jack is fully quoted. 28 U.S. Code 515 says the Attorney General or any other officer of the DOJ or any attorney specially appointed by the AG may, when directed by the AG, conduct any kind of legal proceeding which U.S. attorneys are authorized by law to conduct, whether she's a resident of the district or not. So Jack Smith says, oh, that looks pretty good. So I can kind of do whatever I want. Now, although Jack Smith relies on this section, Section B, the court will analyze both, just to make sure. They say Section 515A, this is Judge Canon, does not authorize the creation of any office. It doesn't say there's a special counsel office. It doesn't say that in here. And it does not authorize the Attorney General to appoint anyone. It says nothing about that. It says what people who are already a part can do. Nor does the special counsel meaningfully argue that it does. He doesn't even reference this in 515. As the text indicates, 515 just simply declares the AG is an officer, says that any officer of the DOJ are authorized to conduct legal proceedings. So that's pretty obvious. And we can't infer that Jack Smith draws powers from that because it doesn't say that. So then Jack Smith turns over to 515B. He devotes a lot more attention to that one. Now, according to Jack, he says that B gives the AG authority to appoint special attorneys, which are kind of like a special counsel. He says this is so because he says it says specially retained under the authority of the DOJ. He says that phrase necessarily means retained by the AG. And so that we can be commissioned and we can be specially retained, that effectively means appoint. Okay, so going back to the subsection, special assistant and specially retained, he's saying that's kind of like special, it kind of sounds like special counsel. So it's kind of close. Each attorney that is specially retained, it's like a special counsel kind of. And it's like a special assistant. So he's like, oh, so that kind of gives me the power to do this. Canon says, these arguments cannot be squared with the text, the context, or the history. It doesn't mean what you think it means. Section 515B, if you just read it plainly, is a logistics-oriented statute that gives technical and procedural content to the position of already retained special attorneys or special assistants. It specifies that those attorneys, again, already retained in the past sense, shall be commissioned. That is, they're already part of the team. Now they're designated, they're entrusted, they're done to assist or as part of a commission. Now, Section 515B then provides that those already retained special attorneys must take an oath And then it directs the Attorney General to fix their annual salary. Nowhere in the law does it give the AG any independent power to appoint officers like Counsel Smith, or anyone else for that matter. So it's just people who are retained. Now, this understanding as a descriptive statute about already retained attorneys is confirmed by additional features in the text. Other courts have already looked at this stuff. And they look at the word retain. It doesn't give anyone power to get anyone new. It says if they're already retained, ed, so it's past tense. And second, absent from section 515b is a reference to any verb that allows an appointment at all. That's an active verb. So to justify that void, so we don't have power to do anything. So to justify that, so Jack Smith realized that, he says, well, you just have to read it differently. So just read the terms specially retained ed and commissioned ed, past tense, as the functional equivalent of appoint. Well, that means they kind of were appointed, right? He says, no, the court is not going to do that. This is linguistic distortion, nor is it aware of any other vesting statute that uses those verbs as replacement for the verb appoint. When they mean appoint, they mean appoint. They don't mean commissioned or specially retained. For starters, the term appoint on the one hand and the terms retain or commission are not even interchangeable. Totally different words. She looked it up in Merriam-Webster's. Retain is different. Commission, right? She went through all the, it's not the same word. We're not going to say the same. Also, Black's Law Dictionary says they're very different words. In any case, even if we do agree that there is some overlap, it remains the case that the Supreme Court has been apprehensive to accept other statutory terms as any stand-ins for the words appoint. The word appoint is a pretty big word in our Constitution, and so we don't just allow it to be watered down. And so if we look at the ordinary meanings of the terms, what does specially retained mean? Or what does commissioned as a special attorney mean? Well, retained means hired, employed. Commissioned means designated, classified. Together, those are fairly mundane. Those are already hired attorneys within the DOJ. They just become classified as special assistants. They take an oath, they get a fixed salary. That's all. That's all we can extract. There's no power to appoint anybody in there. Nor, as special counsel suggests, does the historical pedigree of presidential commission support this. And if we zoom out on this even further, the broader context of Title 28 and the use of the term special attorney within it also refutes Jack. He reads this wrong. It's an axiom of statutory interpretation that identical words used in different parts of the same act are intended to have the same meaning. Section 515 was enacted as part of a wide-scale government reorganization. There are other references to special attorneys talking about Section 519, but the term special attorney has known meaning in Title 28 that corresponds with other terms. And again, special attorneys assist U.S. attorneys. They're not special counsels. Special attorney is like an assistant to help a U.S. attorney. A special counsel is not. This leaves Jack Smith with a problem. Now he's got to figure out how to make special counsel match special attorney. The term special attorney is used in a bunch of different contexts, all meaning the same thing, someone who helps a U.S. attorney. None of the statutes make those match. And there's no basis to believe that Congress, when it designated categories, intended to create an overlap there. So zooming out, if we don't look at those statutes, Congress has repeatedly demonstrated its ability to imbue the Attorney General with appointment power. So they know how to do this too. Congress, for example, authorized the Attorney General to appoint an interim U.S. attorney when offices are vacant, so they know how to do that. Congress authorized the AG to appoint one or more assistant U.S. attorneys, so they know how to do that. They also know how to appoint other heads: education, agriculture, transportation, health and human services. So it's not like Congress was just wrong here or like made a mistake. They know how to make appointments. They know what they were writing. And Jack Smith, you're trying to change the words. The words are clear. The special counsel has no response to this. There's a clear pattern of congressional appointment language. They've been doing it for a long time now. But statutory context cannot be discounted, nor can clear statutory patterns. And so simply put, Jack's strained inferences about Section 515 do not make sense when viewed against Congress. So when Jack goes and reads the actual language, right? So he reads it, he says, crap, this statute sucks for me. The special counsel makes a series of unconvincing historical arguments. He's like, well, Jack says, Congress tacitly authorized this. So because we've been doing it for so long and nobody stopped us, we're allowed to do it. Upon review of the historical record Judge Eileen Canon calls murky, the court determines that whatever themes can be drawn from that historical murky background, they cannot supplant the plain language of the law. So here's some history on this. We'll go quickly through this. But they tell us how the law came into being. In 1930, Congress added the term special attorney. Congress made some non-substantive changes to the wording. But Jack Smith says, all these amendments and Congress's failure to object to the use of special attorneys in the intervening years suggest Congress ratified this. Congress never questioned the power, so they're allowed to do that. Now, for the reasons that Judge Canon says, we're going to decline to interpret Congress's silence as acquiescence here. Just because Congress didn't do anything doesn't mean that Congress didn't speak up to stop this, doesn't mean that you're allowed to do that. Historical practice from Judge Canon, she writes, Jack Smith argues that the use of special attorneys throughout American history confirms that we have authority. Wrong. Judge Canon disagrees. At most, the history reflects an ad hoc, inconsistent practice of naming prosecutors from both inside and outside the government, typically in response to a national scandal, who possessed wildly variant degrees of power and autonomy, because it's just a kangaroo country. Now, the lack of consistency makes it near impossible to draw any near meaningful conclusions. And we've seen this too. We've seen other examples where there was not a U.S. attorney who was appointed. We've also had examples where there was a former U.S. attorney. We've also had situations like Bill Barr appointed prior U.S. judges, right, who have no U.S. attorney background at all. Doesn't make it lawful, just means the people who were at on the subject of those investigatory actions, it's not challenging the jurisdiction of the special prosecutor. So special counsel Jack Smith's broad historical argument comes from two mistaken premises. One is the idea that past AGs have made extensive use of this power. This incorrectly assumes, says Judge Canon, that special attorneys have consistently been appointed pursuant to those statutes. But that's not true. Some special attorneys were appointed by regulation. Some were appointed by statute. President Coolidge appointed with Senate confirmation special prosecutors to investigate the Teapot Dome scandal. Right? So Coolidge knew how to do it. Some were appointed by both, and some, as far as this court can tell, were appointed without any formal statutory or regulatory authority at all, just appointed. And it's just a free-for-all. Thus, it can hardly be said that they've consistently drawn from Section 515. Nor is it true that, quote, past attorney generals were solely and exclusively responsible for the act of appointment. Special prosecutors many times were appointed by presidents, including President Grant with Senate confirmation and President Truman. And the practice and protocol for removing those officers also varied considerably. Now, the second mistaken idea from Jack is a long line of special attorneys of similar ilk. In fact, very few historic special attorneys resemble Jack Smith at all. For starters, the title special counsel is a fairly recent vintage. Special attorney-like figures bore many titles throughout the decades: special attorneys, special assistants, special prosecutors, independent counsels, and more recently, we call them special counsels. Now, in the court's view, this is not an insignificant semantic detail. As discussed below, it shows there are issues here. Moreover, the appointment of private citizens like Jack Smith, as opposed to already retained federal employees, appears much closer to the exception than the rule. It doesn't happen. The historic cases cited by them don't make a lot of sense. Nor is it true that special attorneys have operated with the same degree of power and autonomy as Smith. So Smith has actually less authority than anyone else. Less foundational authority. He's not a U.S. attorney, wasn't even a government employee, just a private citizen. They just shoved him in there. And he had more power. He's prosecuting Trump in 2 different jurisdictions for made-up crimes. Additionally, on several occasions, Congress has helped define and indeed control the degree and the scope of the special counsels. And perhaps most importantly and historically, in the present moment, Congress has shown it knows how to create offices for special counsel. In fact, there are statutes on the book right now that create offices for special counsels with unique jurisdiction. We have this one, Office of the Special Counsel for federal employees and stuff like that. But in the end, there does not appear to be any tradition at all of appointing special attorney-like figures in moments of political scandal through the country's history. There does appear to be a tradition of appointing special attorney-like figures. We don't know what they are exactly, but very few, if any, of these figures actually resemble the position of Jack Smith. They just made his up to go get Trump. Mr. Smith is a private citizen, and he's exercising the full power of a U.S. attorney. He has very little oversight, if any, or supervision. When scrutinized, this spotty historical backdrop does not amply confirm that he has authority. Whatever marginal support the history may lend to Jack Smith's position, the inconsistent patchwork of practices does not show that Congress ratified or acquiesced to that interpretation of 515. Does not overcome the plain language here. And Jack Smith is not an assistant, so the rules don't work. And 28 U.S. Code 533, same problem here. They are relying upon 533. They say, here's what the Attorney General can do. He may appoint officials to detect and prosecute crimes against the United States, to assist in the protection of the person of the president, to assist in the protection of the AG, and to conduct other investigations under the control of the DOJ and the Department of State as directed by the AG. So Jack is saying, oh, perfect. Okay, that's the one. That's my home run right there. So Attorney General can appoint an official to conduct another investigation. There's my hole. Now, as a preliminary point, the appointment order issued in November 2022 is the first appointment order or regulation that has cited 533 as a source. Never happened before. The special counsel regulation promulgated in 1999, which replaced the independent counsel, also does not cite 533. Nor did the regulation appointing the special prosecutor in Nixon cite 533. Nor did Robert Mueller cite that. So they just made it up. Special counsel Smith argues that 533 does give him power, and after a careful review, the court says, no, it doesn't. Congress does not hide elephants in mouse holes. You don't get to be a special prosecutor because of this section, other investigations. That's what they meant, other investigations. The plain language would be inconsistent with the basic separation of powers principle. They didn't tuck in that power in this statute. May appoint officials, right? That's different than officers. So let's see what Judge Canon does with that. It says officials is not the same thing as officers, so it doesn't cover you, Jack, whether you're an inferior or not officer. Section 533.1 authorizes the AG to appoint individuals to detect and prosecute crimes. Now, the parties dispute the proper interpretation of the term officials. Trump argues officials is most naturally read as non-officer employees. Jack says no, officials covers officers and employees, but Canon agrees with Trump. Jack is such a dishonest piece of work. I'm glad he's losing this so badly. It's just embarrassing for him, again, to lose so badly, but that's what he deserves. But they're going to, this other investigations and official matters, that's going to, the entire independent counsel or special counsel statute is just tucked in there. It's such a joke. Now they continue saying, courts interpreting statutes look to the plain and ordinary meaning. Definitions of officer emphasize a degree of elevated authority. Some definitions overlap, no doubt. Official is more of a general class of bureaucratic personnel. Officer versus official, they're different words. Again, looking to the dictionary. Now, there are some terms where officials can be a catch-all phrase for employees and officers, and context matters. But when I read it in context, the words are much narrower than what Jack says. Like all statutory terms, officials does not stand alone, but it gets meaning from the words around it. When read in relation to the other words, it doesn't give Jack Smith the power to appoint a special counsel. It describes security and investigative employees within the FBI, bureaucratic personnel. And while undoubtedly important, they're not special counsel. The phrase detect and prosecute crimes does not authorize them to become special counsels. This is an FBI provision, all right? It's not a DOJ provision. And it draws from applicable dictionary definitions. It's not the DOJ prosecuting, it's the FBI prosecuting. So it means to follow up, right, to investigate. This could include FBI attorneys, other legal staff, but it's FBI agents. It's not special counsel because it's in the FBI section. Nor is the court persuaded by Jack's suggestion that officials makes other portions of the statute inapplicable. And if we read these as the same, it would be opposite of Congress's intentions. Congress talks about officers and employees distinctly for agriculture, for education, for health and human services. You can't commingle the two. Congress has an interest in separating those out because officers are appointed and the others are not. Officials are not. So Congress wants you to read things how they write them, and that's what we're going to do. And some consistent legislative practice shows that 533 is talking about officials, it's not talking about officers, and it's not stylistic. And by the way, 533 is in the FBI chapter. It's not in the DOJ chapter. It's tucked in here. It's sandwiched between 532, which is a statute about the appointment of the director of the FBI, and acquisition of criminal evidence. And so given its location, it's not a special counsel statute. It's in the chapter about the FBI. So it doesn't apply. And so here, what Judge Canon says is, if we just read what the law says, it does not provide a basis in law. There is no law, any one of those codes or federal regulations that approves and authorizes Jack Smith to be here. Now, when we zoom out, all of the laws have been dealt with. But on a more fundamental level, if we interpret this as Jack wants, we're in big trouble. We have a separation of powers problem. As we see here, Congress has carefully enacted this statutory scheme. This governs the appointment of these officials. Most relevant here, U.S. attorneys are really the people who most closely resemble Jack Smith, and those people have to get appointed by the president and confirmed by the Senate. If we allow Jack Smith and Merrick Garland to do this without any congressional input, that strips Congress of its role in the appointment process. Now, absent a statute, we have to have some power that appoints Smith. And we don't have that here. And so this court, Judge Canon, is going to decline to dilute the appointment power. We're not just going to say that these provisions give Biden the power to appoint whoever he wants. Now, the parties disagree. You keep hearing about this Nixon case. The court emphasizes this is the statement that they keep hanging their hat on. It has also vested in him the power to appoint subordinate officers to assist him in the discharge of his duties. Now, Trump argues that Nixon and the statement in that case about the Attorney General's authority is non-binding dictum. Dictum is just superfluous language. It's just kind of, think of it like a tangent, right? You're answering a question, someone asks you a specific question, you start to explain your answer, then you start talking about that time at the grocery store where that guy didn't put his cart back and you said the thing, and then you come back to your main point. And then you finish. But that cart story is all dictum. Doesn't actually go to the, it may have been about something else, kind of irrelevant, but maybe it was illustrating a point, but it's not binding. And thus it should not control. Jack says, yes, it should. Now, following a comprehensive review of the court record, Judge Canon says it is dictum. Okay, it doesn't matter. It's not binding. The issue of the Attorney General's appointment and whether he was even authorized was not raised. It was not briefed. It was not argued. It wasn't even disputed. Nobody even cared. Nixon is undoubtedly precedential in other areas, subpoenas and other things, but not about appointment authority. It wasn't a case about appointment. The points are not binding on this court, and so we are moving forward appropriately. And so we're distinguishing dicta from the holding. And she's going to walk us through all of that, which we'll fast forward through, talking about Nixon and the Supreme Court and walking us through that entire case. You can see this is a whole section on this. So with this context, it is dictum. That case is just, it doesn't apply. The Supreme Court granted certiorari to decide 6 questions. So when it went up, 5 were from the special prosecutor, 1 was from Nixon. Here were the questions that came out in the case. And that was not raised in the case. Whether the attorney generals, the same is not true of the statutory appointment authority, a peripheral subject that was not even raised in the case. So there were other issues, but it wasn't whether the special prosecutor was valid. It was uncontested there. So a case is not binding precedent if it wasn't raised in the case. Across hundreds of pages of briefings and hours of oral arguments, neither party ever challenged the special prosecutor's validity or the AG's appointment authority to appoint the special prosecutor. In fact, on numerous occasions, Nixon expressly stated that he did not contest these points. So you can't use that as binding because it wasn't about this. Now, even though authorization was not at issue, Jack Smith still contends that Nixon's comment on this point formed a necessary element of its holding. So she's going to take us back through that opinion and say why it doesn't apply. Nixon did not analyze statutes. Nixon was decided prior to the development of recent appointments clause jurisprudence, and so it just does not apply. And it's out-of-circuit cases. It's an out-of-circuit case that he's using to interpret Nixon, and so those don't apply there in Florida. So now we move forward. In the next section, Canon tells us that we need to discuss this concept about being a principal versus an inferior officer. She writes, "This brings us to the final point on the Appointments Clause challenge. Before we address the remedy and how we fix this problem. Now, up to this juncture, the court has proceeded under the idea advanced by Jack that he is an inferior officer, which is not true, not a principal officer requiring presidential nomination and senatorial consent. Weird. Why would a U.S. attorney who prosecutes people need those things, but Jack Smith, who is also prosecuting people, not need those things? Defendants and the Ms. Amici contest this assertion, and it's a point worthy of consideration given the virtually unchecked power given to Jack Smith under the special counsel regs. Ultimately, however, after examining the broad language in the Supreme Court cases on this subject and seeing a mixed picture, even if a compelling one in favor of a principal designation, the court still elects, with reservations, to reject the principal officer submission and to leave the matter for review by higher courts. So someone else can figure that out. Either way, though, Jack loses. Now, arguments here. Jack says, no, I am an inferior officer. I'm not like the main guy. I'm subordinate to somebody, which means I don't need to be appointed and confirmed. But then they say he isn't not supervised at all because he's like this independent special counsel, which kind of makes him not an inferior officer, a principal officer. So he cites Morrison and Edmund. He says, no, I can be removed for good cause, and I have limited duties, and I have limited jurisdiction based on my order, and I report to Merrick Garland. And so I can be removed. So because I can be fired, it means I'm not a principal. Now, defendants and the Ms. Amici, who did an amazing job on this work, may have gotten this case dismissed, actually, take the principal officer view, urging that the special counsel wields the same authority as a U.S. attorney. And he's got regulations. He has no authority to do that. He doesn't have a functional supervisor. He doesn't have an at-will removal. And so at the bottom, he is a principal, and his appointment needs to come from the president. The judge will walk us through some standards and walks us through some case law. Now, the courts have asked this question. Are you an inferior or principal officer? How do you tell? There's a test. Whether an officer is subject to substantial supervision and direction of a principal officer. So is Merrick Garland giving Jack Smith substantial supervision and direction? No. And 2, whether an officer is removable without cause, perhaps the weightiest factor, and whether an officer's decisions are subject to reversal by a supervisor in the executive branch. And we don't know the answer to that. Does Merrick Garland, is he going to rubber stamp, sign off on Jack's indictments? Did he or not? We believe he did. Could he remove Jack without cause? I don't know. Again, Canon says, the Supreme Court has been careful not to create a rigid test because it's difficult to determine. So against this backdrop, we now have to ask ourselves, is Jack Smith an inferior or a principal officer? Now, as a preliminary matter, Canon says, the parties agree the court should elevate the principal versus inferior question, and indeed the entire dispute, as a matter of law. And so we'll do that. The court expresses some hesitation in this regard and lacks a detailed understanding of the actual extent and the mechanics and supervision and control over Special Counsel Smith, right? So the judge is even saying, I don't even know how he's governed. So we're going to try to do some analysis on this, but it's so murky that we don't really know. Is he governed by Merrick Garland? Does he report to him? Can he be fired? Who knows? Nevertheless, since neither party pressed for an evidentiary hearing on this issue, Jack Smith appears to have taken the questionable position that such inquiries intrude upon privilege. So you can't ask how I'm being governed, okay? You can't ask if anybody's supervising me because that's internal deliberation attorney privilege. Very convenient. And the court generally agrees that judicial treatment of appointments clause challenges has tracked the level of supervision and direction by reference to statutes and regulations only. The court thus proceeds accordingly, referencing the regulatory framework in time, and that's all. And so basically, she says, based on what I see in the rules, so you guys keep referencing these regulations, so I'll just look at the regulations and see if there's any supervision over you, Jack. Because you say the regulations give you power to be here. So they must also provide some context for how you're governed, right? So let's look at the regulations that you guys love so much. So she says, okay, well, the special counsel regulations give to Jack Smith an exceedingly broad charge. He can exercise, within the scope of his jurisdiction, the power and independent authority to exercise all investigative and prosecutorial functions of any U.S. attorney. So she goes, holy crap. So, okay, if we think that these regulations are valid and we're taking your word for it, according to your own rules, you have no mechanism for supervision or control by the AG. So you're totally free for all, according to your own rules. Okay, so that means you're kind of a principal. Several key features inform this view, tracking the regulations on this subject. Now, what's more, during the hearing, and specifically during questioning about the degree of direction and supervision, here's a footnote. Counsel for Jack Smith refused to answer the court's questions about whether the Attorney General has played any actual role in seeking or improving the indictment in this case. We don't even know. Did Merrick Garland even look at it, sign off on it? In doing so, counsel appeared to invoke a deliberative process privilege or other standard Justice Department policy privilege. Canon is so sick of these people, although none of the court's questions solicited the substance of any of the internal deliberations at all. Ultimately, counsel for Jack Smith appeared to acknowledge some degree of actual oversight consistent with the regulations, but again, resisted any further representation. Why would the prosecutors be trying to hide the structure? What did you come out? Yeah, no, Merrick Garland. This is how it works. Merrick Garland is in charge of Jack Smith, and he reviews this and he reviews that. Why do they have to hide everything? Because it's a conflict. Because they know it's illegal. So she says, okay, well, if you're not going to answer my questions, then I guess I'll just have to look at the rules. Okay, so several features of this now come out. First, Jack Smith is under no regulatory obligation to talk to Garland at all. That's from their own regs, which are now illegal. Quite the opposite. It's up to the special counsel to determine whether to inform or consult with the AG. So Jack Smith gets to decide whether he talks to Garland or not. So who's really in charge? And second, a special counsel must comply with the rules and regulations, and he shall consult with appropriate offices. But nothing in that policy is a directive that applies only to consultation with. Appears to limit the decision-making in conducting an investigation and prosecution. Third, still on the subject of the consultation, the special counsel has full discretion about how to do that. And mechanisms for notification, nothing in the provisions actually require them to do anything other than notify the Attorney General. And basically, the regulations also remove the day-to-day supervision and provide no countermanding authority for the AG. And so it basically leaves the AG a very slim route to countermand the decision only after the AG, lots more law there. In sum, this framework does not lend itself to saying that Jack Smith's work is directed and supervised at some level by Garland, unless it's exceedingly broad. So if the courts want to interpret it extremely broadly, then they can. But can we remove Jack Smith? This element features prominently in these other cases, the regulations say that, yeah, he can be removed from office only by a personal action of the AG for misconduct, dereliction of duty, incapacity, conflict, and for other good cause. Wow, okay, so it's not at will. The regulations do not say he can remove them at will. So what do we say? We don't know. There's a problem here. And so while it seems the absence of at-will removal is a key feature, it could transform Smith into a principal officer. We're going to hold off on that. She says we'll let the higher courts deal with it. And there's one final issue as it relates to removal. It's Jack Smith's fallback position that none of the removal limitations pose an impediment to inferior officer status. They say, in other words, Jack Smith relies on regulations for some things, but then discards them when they're inconvenient. Just typically what Democrats do anyways. So the special counsel's defined jurisdiction presents an unhelpful picture. The final component of this, Jack Smith says that his jurisdiction is limited. But they are broad. They are as broad as any U.S. attorney. In some degree, they're even broader than a U.S. attorney. He's permitted to investigate multiple districts within the same investigation. So he does not even have limited jurisdiction. What is unlimited? The answers are hazy. We don't really know. And so he has a ton of power and tenure. While it's true that it will end at the conclusion of his work, limited tenure, it's not meaningful in any sense. And so when you bring these things together, it's confusing. These are unclear, but they remain an amalgam of considerations in Supreme Court case law. And so, for the above reasons, the court sees compelling reasons to think that he is a principal. The answer is not clear under current Supreme Court precedent, but we'll leave this for further review. But what do we do now? So Judge Canon continues. Now that we know Jack Smith is illegally appointed and has been dipping into a fund that is not his, the court says, what do we do about this? What is the remedial question here? What do we do about the absence of law that authorizes Jack Smith? Trump wants this case dismissed. He says he can't even prosecute this. And so anything that he's done is ultra virus. It's outside of the scope. Jack says no. Jack Smith says, I am allowed to do this, but there's no alternative form of relief. He just says, I can prosecute it, end of story. Now, because Jack Smith's exercise of prosecutorial power has not been authorized by law, the court sees no way forward aside from dismissal of the indictment. And Jack Smith has no alternative. What are you going to do, Jack? Man, such a great opinion. This is outstanding. The Supreme Court's decision serves as the best comparator for remedies. When the prosecution is illegitimate, everything has to go. Same thing should be happening with Fani Willis and now the J6 case. It bears noting that Jack Smith's work cannot be salvaged by the de facto officer doctrine. Can we just substitute him out? Can we just slot in some other U.S. attorney? First of all, that doesn't apply here, she says. And any other rule would be a problem because defendants raised their objection. There is no valid officer without a valid, and there is no valid officer without a valid office. This case is gone. Now, the judge continues, wants to talk about the Appropriations Clause, the money. Since its inception, Jack's office has been funded by a permanent indefinite appropriation. That was originally for the independent counsel. That means that Jack Smith's office has been drawing funds, right, as discussed above, because he was not lawfully appointed. He was stealing money. He has been drawing funds from the Treasury without statutory authorization in violation of the Appropriations Clause. Sick. $24 million stolen by an illegal appointment from Merrick Garland. The Appropriations Clause says no money shall be drawn from the Treasury, but in consequence of appropriations made by law. It plays a critical role. Congress has the power of the purse, as we see here. As a historical matter, it's the most complete and effectual weapon to ensure other branches don't exceed their authority, except Congress is spineless, so they never use it. By its terms, indefinite appropriation is only available to independent counsels. For all the reasons the court found above, Jack Smith's investigation has unlawfully drawn funds from the indefinite appropriation. Jack Smith stole $24 million. Merrick Garland and the DOJ stole $24 million from the independent counsel fund, and they unlawfully drew them to give it to an illegal prosecutor to prosecute Trump. Stolen money. Wonder if anything will happen. Having found no other law, the court need not determine whether Jack Smith is the type of independent counsel. He's not. Nevertheless, the court says there is inherent tension in the special counsel's position in this issue, in the Appointments Clause context specifically. In arguing that he is an inferior officer, he emphasizes the AG's supervision and control. But in the Appropriations Clause, he asserts he's sufficiently independent to draw the funds from appropriation. See how that works? He's trying to have it both ways. In other words, Jack Smith says he's independent enough to access the independent funds, but he's not so independent as to constitute a principal officer. So he doesn't want to be appointed and confirmed because he's just working for mayor, but he wants all of that unlimited money for independent counsels because he's independent counsel. Total corruption. Now, perhaps he threads that needle, but at least one source suggests otherwise. In 2004, the GAO, Government Accountability Office, approved Special Counsel Patrick Fitzgerald's use of funds from indefinite appropriation. And they found reasons for that. But as mentioned above, we don't need to do that analysis here because Jack is unlawfully appointed. And getting to the end, the judge says, well, that leaves a remedy for the Appropriations Clause. So we know if Jack Smith is not in a lawful office or lawfully appointed, the case goes away. The remedy is a dismissal of the indictment, but what is the remedy for the stolen money? Trump argues the only way to cure the funding violation, and dismissal is the only way to cure that. Now, Jack Smith opposes the dismissal, asserting without any specificity or even willingness to engage in fact-finding, they just say, we could get the money elsewhere. The department could have readily funded the special counsel from other appropriations that were available. And so they said at a high relativity, high level of generality, that the DOJ has appropriated over $1 billion. And some of that went to Jack Smith. Now, the court doesn't need to reach the remedy here because Jack Smith, yeah. But as discussed below, we believe the Appropriations Clause violation is also an independent basis to dismiss this case. So either way, it's gone. More case law on this. Jack's office has spent tens of millions of dollars since November 2022, all drawn unconstitutionally from an indefinite slush fund. That funding has served as the very lifeblood that empowered Jack to exist. Perhaps, as suggested generally at the hearing, the DOJ could reallocate funds to finance the continued operation of Jack's office, but that would require further development of the record. But even if this were possible, what to make of the prior action? For more than 18 months, Jack Smith's investigation has been financed by $24 million plus, drawn from the Treasury without permission. They try to rewrite history at this point. It seems near impossible. Canon says the court has difficulty seeing how a remedy short of dismissal would cure this, but answers are not entirely self-evident, and the case law is not well developed. For the first time, for that reason, and given the disposition of the order, the court leaves this matter for future review. Canon wraps up 93 pages of brilliance. Says, upon careful consideration of the foundational challenge raised in the motion, the court is convinced that Jack Smith's prosecution of this action breaches two structural cornerstones of our constitutional scheme: the role of Congress in the appointment of constitutional officers and the role of Congress in authorizing expenditures. The framers gave Congress a pivotal role in the appointment of principal and inferior officers. That role cannot be usurped by Joe Biden and Merrick Garland and diffused elsewhere, whether in this case or others, whether in times of heightened national need or not. In the case of inferior officers, that means that Congress is empowered to decide if it wishes to vest appointment to powers of heads of departments. And indeed, Congress has proven itself quite capable of doing so in many other statutory contexts. But it plainly didn't do that here, despite Jack Smith's strained statutory readings, nor does his appeal to inconsistent, quote, historical practice supplant the absence of textual authorization for his appointment. You can't just look at the history books and say, they kind of did something similar, Mom, so can we do it too? The same structural emphasis resonate in the context of appropriations. Now, in the end, it seems that the executive's growing comfort with appointing regulatory through the CFR special counsels in the more recent era has followed an ad hoc pattern with little judicial scrutiny. The judges all look the other way because they're weak, but not Canon. Perhaps this can be traced back to the reliance on the stray dictum in Nixon that perpetuated the substantive cases. Perhaps it can be justified practically by the urgency of national crises. Nobody looks at it. Or perhaps it can be explained by the relative infrequency of these types of investigations, by congressional inattention, or by the important roles that special counsel-like figures have played in our country's history. Now, regardless of the explanation, the present motion requires careful analysis of the statutory landscape to ensure compliance with the Constitution, and the court has done that here. And so the court thus returns to where it started. The Appointments Clause is among the most significant structural safeguards of the constitutional scheme. So too is Appropriations, which carefully separates congressional control of the purse from the executive control of the sword. The consequences of relaxing either of these critical provisions are serious, both in this case and beyond. As Justice Frankfurter explained in his opinion in Youngstown, the accretion of dangerous power does not come in a day. It does come, however slowly, from the generative forces of unchecked disregard of the restrictions that fence in even the most disinterested assertion of authority. Illegitimate and unconstitutional practices get their first footing by silent approaches and slight deviations from legal modes of procedure. And so, for the reasons set forth, Judge Canon, in conclusion, drops this absolute bomb on Jack Smith. It is hereby ordered and adjudged that Trump's motion to dismiss the superseding indictment based on Jack Smith's unlawful appointment and unlawful funding is hereby granted. The indictment is dismissed. This order is only limited to this proceeding, and this order doesn't weaken any of the protections for the classified docs, but the clerk in Florida is directed to close this case. Any scheduled hearings are canceled. Any pending motions are denied as moot. Any pending deadlines are terminated. Done and ordered in chambers by our friend, Judge Eileen Canon. Amazing filing, 93 pages. One of the most meticulous decisions you've ever seen. In fact, this is, I think, even more than she needed to drop on this. This goes on and on and on. She spends pages that we fast forwarded through talking about Nixon and how that was just pure dicta, and how every even subsection is inappropriate to granting them the power. And what you'll notice here, it's so thorough that she even analyzed other sections that Jack Smith was not even relying on. We saw she was talking about subsection A. Let me get rid of that too. I know you're only relying on B, but let me make sure that we get rid of A too. And so 93 pages of brilliance. This is a decision that is going to send Jack Smith and the left through the roof, because it will now create a circuit split. The same question is now going to land on Judge Chutkan's desk, and she's going to have to ask herself, how am I going to respond to this? Chutkan now has to create an opinion that is the opposite of this, but it's also true. Everything that Canon laid out, Chutkan's going to have to reverse. And she's going to have to find that Jack Smith is lawful, that all these provisions that we read here today that show that there is no power, she's going to have to say, well, I think there is power. And she's going to use this umbrella tactic and try to connect all the statutes together and go back through the history and say Canon was wrong. And so we're going to see this continue to develop. Trump is going to take this decision and dump it right on her desk and say, you know, I know that you don't have to be bound by this precedent. I know it's not binding, it's in Florida. But you've also referenced, and we've seen other people reference in your courtroom and elsewhere, persuasive cases involving Trump. Remember, every time Trump gets gagged, they take that snowball that's rolling down the mountain and they dump it into another court. So then they'll say, oh, Trump was gagged in the E. Jean Carroll case. Oh, Trump was gagged by Engeron. And so now, Chutkan, you have to gag him too. And then they did that in the Bragg case. Oh, Trump was gagged in Carroll's case, in Bragg's case, and Chutkan's case. And so you too, Judge, need to gag him too. So if they can take all of these other cases and use them as persuasive authority in Trump's other cases, surely this from Judge Canon, and it's not just Judge Cannon's opinion on this, by the way, she also has the support of Clarence Thomas, who in his concurring opinion in the Trump Supreme Court case that just came down on immunity, confirmed that Jack Smith doesn't have any lawful authority. And just because mom didn't catch you when you were prosecuting your case, Jack, doesn't mean that mom allowed that to happen. All right, we've all been there. Mom finds out you're doing it. You were doing that for how long? Oh, you're in trouble. So that's what's now happened, is finally Trump has raised this case. But Jack Smith is the most illegitimate special counsel, special prosecutor that maybe has ever existed in this country. Came over from the International Criminal Court, thought that he was going to drive home 2 home runs, and his case, the classified documents case, which many people thought was the most serious of all the cases, is now dead and gone. And so he can try to appeal it. No doubt he will. And there will be a lot more reaction on this. But it is a big, big victory for Trump. This case should have never been brought. There should be repercussions for this. I want to know where the $24 million went and how we're going to get that back. Who's going to be held accountable for that? Hopefully Congress investigates that and maybe takes that $24 million away from their budget. They don't need that next year. They already wasted it. And people should be prosecuted for this, quite frankly, because this is a conspiracy to use the law to pervert the office, right? It's an abuse of public office to go wage war against your political opponents. And Judge Canon, I had my doubts about it. I thought that she was not going to do this because it's a big deal. It's a huge deal. It shatters the DOJ's fake special counsel scam. And it's huge because they used the special counsel scam, even with Robert Mueller, to go after Trump. And so think about what this might do to the future prospect of special counsels. They used that to drag Trump down his entire first administration. And so if Trump wins again, and they have a lot tighter reins on the power to use rigged prosecutions, that's good news for Trump. So an absolutely amazing day. I mean, I was not expecting this. It's a beautiful Monday morning after a heck of a weekend. We wake up and Judge Canon drops this right out of the oven, fresh for us to read, 93 pages of amazing goodness. And we're glad to see that this decision came down the way that it did. So very good stuff over there. Let's see what else is cooking. So that was the decision, and a brilliant one from Canon. And let's see if there's any other reaction that is out there, because I know this is breaking. It's fresh out of the oven. And we also have reaction from the Oversight Committee, for example. They just posted this. James Comer and the Oversight Committee are sharing some reaction to the classified documents situation, sharing, I applaud, this is from Comer, I applaud the judge's decision to dismiss the classified documents case. Democrats' effort to weaponize the legal system against Republicans are unraveling before our eyes. The immunity decision is probably going to unravel all of them. And now this. The American people are not fooled by the Biden administration's political prosecutions against President Trump. Democratic lawfare must end. So a great statement from the president. I'm sorry, from James Comer. And I was looking for another update from the president to see if he has anything new for us. And let's see. Vivek was out. Let's see what Vivek was saying this morning. Here's what he said.
It has called a Republican president a tyrant, a dictator, said it would be the end of the United States of America as we know it, said he would make us a laughingstock on the global stage. And those are exact quotes, actually, of what they said about Abraham Lincoln. Saw the Lincoln hat, you might have wanted me to remember that. Those were words that the Democrat-led media said about the first ever Republican president before he was shot and assassinated in 1865. So think about that in the moment that we live in today. We came within, Lincoln actually spoke at this convention. It was at a Republican convention. It was at a state convention, Republican state convention, I think in 1858, when he said a house divided cannot stand. That was on the eve of a nation that was on the brink of civil war. I think we came within a hair's breadth of a second civil war in this country, and we avoided it. And I think it's because God intervened. And I believe that he has given us a chance to answer his call. Amen. And I think that's the moment we live in right now. Is the hard part is we are in a kind of war in this country. Yeah. But the enemy is not our fellow citizens. No. Actually. It is an ideology. That's right. And so this is the work we have cut out ahead of us, is how do we win this war? while still viewing our neighbors as our fellow citizens and not as our enemy combatants? Are we up to that challenge? I believe we are.
All right, so that is Vivek out there making some statements. Of course, big day. Still a lot to follow up on the assassination. We also have some new news. Apparently, Trump is going to be naming his VP candidate today. Oh my gosh, it's just out of control. Some people saying that it might be J.D. Vance, and people are reporting that J.D. Vance is leaving his motorcade and heading over to the event. So who knows if that's happening or what's going on. But here's what Martha McCallum is sharing with us over on X. Senator J.D. Vance departs his motorcade as he heads back on over to apparently the RNC. And C-SPAN has some RNC stuff cooking right now. You can see this is what it looks like there. This is a call coming in from Ohio. Let's check this out.
J.D. Vance. And I read his book.
All right,
his book was very good.
All right, well, Carolyn, it's that you also like Sherrod Brown. In November, Sherrod Brown's up for re-election. Will you split your ticket?
All right, so you can see looking like there's a lot of fun going on over there, and we'll keep our eye on it. Apparently, the announcement is going to come at about 4:30. Is that right? Or it could be Ben Carson, some people are saying. Wow, okay, so time will tell. But apparently the news is Trump is going to be picking the VP candidate today. So keep our eyes peeled, my friends. To announce his VP pick on Monday, here's the story. Fox News reporter Brett Baer said that Trump told him he will announce on Monday. Baer made the comments to Fox TV. That's the story. All right, so coming up soon, my friends, it's going to be a heck of a day, a heck of a week, a heck of a Monday. And so an amazing decision. We're going to have a new VP candidate. Big questions, who we think it's going to be. Time will tell. It's going to be a wild day. All right, so RNC convention is underway. And let's hear from you, my friends. Let's talk about it. Let's see what you say about all of this and more, because we've got a lot cooking. All right, so my friends, thank you for sending in these amazing donos and super chats. Of course, we're going to say what's up to our friends on Locals and see what you guys say about this. Elise Stefanik, someone's throwing out there as a prospect. Good questions. And hey, I wanted to read this comment from yesterday. So we have a friend called Rai T, and he lives in the UK. And he posted a very nice comment on our Locals yesterday, and I wanted to read this with us here today because I think this was a nice message from our friends in the UK. So let me share this with you, and then we'll jump into some of your comments and thoughts. But here's what Rai T said. He says, this was yesterday after the assassination attempt. Says, "Hi, Robin watchers. My thoughts are with the deceased and his family, the injured and their families, and everybody else affected by the tragedy that has been bestowed on us by those responsible. I'm so sorry this happened to you all. I'm even more sorry so many of us expected it. The audacity of those that have been instigating this hatred by taking every opportunity to villainize Trump and his supporters to suddenly now come out and call for calm language and less hatred in politics. How bloody dare they?" He's from the UK. "Them and everybody who has sympathized with their lies should be ashamed of themselves. They must take responsibility for their part in this. My American friends who are shocked and hurt today, I say this: keep calm and carry on. You are on the right side of history. The universe is on your side. Do not let their hatred of you and your way of life cause you to hesitate for even a moment in doing what you know in your heart is right. Ignore their denial of what you know in your heart is true. Deny their hatred for what you hold in your heart out of love. America shall prevail, and her people shall be free. God bless the USA." From our friend Rai T, from across the pond over there in the UK. Great comment, Rai. I do appreciate that. I know many of us do appreciate that. And we thank you for your support from over there. Very powerful stuff. We are going to keep on and keep on. That's for sure. And every time something like this happens, it just solidifies our resolve. So thanks for that, Rai T. My friends, we had some great comments in the house. What's up, Mima? Brought in 5 new membos. Thank you, Mima, for doing that. My newest friends, welcome aboard. Thanks to Mima. We got this one from Brooks Kelly. Says, "Did Jack Smith just wet his pants or what? He's not happy today. He's having a bad morning. He's having a bad couple of weeks. I mean, first of all, Jack Smith has to deal with the immunity decision. So he's got to go back down and handle that with Judge Chutkin. Now he also has his entire January 6th case dismissed. Somebody better check on Jay Bratt, man. They're having a rough day down there in Florida." Rob White says, The doc's evidence is fruit of the poisonous tree now. Yeah. I mean, everything is. That's basically what that means. So the concept of fruit of the poisonous tree is if you have a poisonous tree, you can't eat the fruit, right? So if the tree gets poisoned, you can't eat the fruit because the whole thing is bad. So it's something that often exists in search and seizure law, right? If the police enter your home illegally without a warrant or exigent circumstances and they see something, well, there was an illegality that happened, and so what comes after the illegality is thrown out. It's fruit of the poisonous tree. Same thing happened here. Except it was the whole case. But and honestly, this thing should have happened with Fannie too. She was so conflicted and corrupted off that case should have been dismissed, but obviously it wasn't. What's up, Mama Rowe says, great day for victory and for a VP unveiling. Patriots W in the house. What a day. We had this one also from MJ Powell sending a super sticker. Thank you, MJ Powell, for sending that one in. Very nice of you to be here. Hey, Barb loves Alaska says, Canon doesn't have jurisdiction in those other states. Is that why maybe she didn't stop those other cases? Exactly, Barbs. Yeah, you nailed it exactly. She's only in Florida. So she doesn't have any authority over the J6 case or the Georgia case or what's happening in New York or elsewhere. You nailed it exactly. Well done. Revco says, Jack needs to find a job in his speed. Something that involves asking, do you want fries with that? And even that might be a bit above his skill level. We don't even know what Jack Smith has done ultimately, other than hire Jay Bratt and others. So yeah, he should go back to the International Criminal Court and just leave us alone. Hey, what's up, Knights? He should be prosecuted, actually, for violating his law. Jack Smith knowingly broke crimes. He did it under the cover of law, but they were criminal acts. Knights of Knee says, thanks, Rob. You're my go-to Trump legal expert. Thanks for that, Knights of Knee. We do read a lot of documents here. That is for sure. What's up, Don McGrawdy? What's up, Membo? For 6 months, that's 2/3 of the way to a new baby. Says, hello, Robin fam. Sending love and light. Good to see you, Don. Thanks for stopping by this morning. We got this one from Jeffrey Adams. Says, nothing says F you like dismissing your lawfare case. Jack, Joe, and Merrick early on a Monday morning. Yeah, and she did it right after the assassination attempt. So it's just like win, win, win for Trump. All I do is win no matter what. What's up, Gloria B? Hey, one new membo coming in. Good to see you, new membos in the house. We got Paula Nick says, what happens to the documents? Could they have been looking for a specific document? Trump's insurance. That's a good question. I don't know if they were looking for a specific document, but theoretically, let's set aside the classified documents case. But like if you're just taking a regular case and they seize your gun or something like that, your case dismissed, you get your gun back. Unless there's some other reason for them to seize it or have it, but there usually isn't. So you get that back. So these are classified documents. I don't know if Trump's going to demand those documents back or if they've already been reinserted into the archives or what has happened to those, right? Because a lot of this is very opaque. We can't see anything about what's happening with CISA and all the stuff behind the scenes. But yeah, normally evidence that was yours that they've seized, you get back when the case is dismissed, right? Absent, drugs and stuff like that. Or if it was instrumentality in the crimes or something, right? You're not going to get like your bag of cocaine back. But generally speaking, yeah, you will get evidence back. Classified documents are in their own category. What's up? Don Malone says people need to develop their schema in a broader cognitive framework. Instead, replace critical thinking with introjection in the process of internalizing external beliefs or values without critical examination. Damn, that's a smart sounding language sentence right there. People need to develop their schema in a broader cognitive framework. So like your worldview, your paradigm, like your schema, like how you classify things. Instead, they replace critical thinking with introjection, the process of internalizing external beliefs and values without critical examination. Yeah, so it sounds like what you're saying is people just kind of get programmed. They don't actually critically think. They just do whatever Joe Brzezinski tells them to do. Thanks for that one, Don. We have this one from Ken L. Says 43 stat, 5-inch. And the Prez further authorized. And the Prez is further authorized and directed to appoint, by and with the advice and the consent of the Senate Special Counsel, approved by O. Roberts, A. Pomerantz, appointed by POTUS, and confirmed by the Senate. From Ken L. Thank you, Ken, for that nice super chat. I appreciate you being here. Thanks for sending that one in. Jeffrey Adams says, Rob, want to guess which judge has the 11th? Yes, I do. Clarence Thomas. What's up, Clarence? Alice Arrowwood became a YouTube member. Thanks for that one. Welcome aboard, Alice. Dennis P. is here. Says, this is a technicality. It's not based on the merits. I'd still like to see a decision on the merits from an impartial party here and the DC case. So do you mean you want this case to go to a jury trial? Is that what you're saying? You want the January 6th case and the Florida classified documents case to go forward to a full panel and we have an evidence on the merits of the trial? It would be a corrupted trial because it would be a corrupt prosecutor. But I understand the idea of maybe wanting to see it play out in court. But it's an illegitimate prosecution. So why would we enable an illegitimate prosecution to see an actual trial on the merits of the indictment? Jack Mack is here. Says, okay, so the U.S. government failed to do this within their own regulatory guidelines. They spent how much of our tax dollars, over $20 million, on this through Jack the Hack Smith? I mean, is ineptitude excusable? I would qualify as fraud, waste, and abuse. Yeah, I would. I don't think it's ineptitude at all. I think it's strategic, weaponized lawfare. They knew that they had this slush fund. They knew that they were going to try to just... Their goal was to try to do it first and ask questions later, right? Deal with the ramifications after the fact. So they appointed him to try to take him out. They got busted. Supreme Court has stepped in. But it's willful, intentional lawfare. And it's an abuse of public office. And I think they should be prosecuted for it. So they stole money. And they stole money to prosecute Trump. There should be serious repercussions. Will there be? No. Hey, what's up? Peter B. says yes to using the Stelter voice for Adam Schiff. The Stelter voice for Adam Schiff. They all kind of sound the same to me. You know, it's hard to distinguish between them because a lot of them kind of look and sound the same too. It's weird phenomenon. David Webb. What's up, David Webb? Thanks for becoming a new YouTube member. Great to see you stop by. Thanks for doing that. MH Cassidy sends in a nice dono. Says, in all cases, can Trump sue to get back his legal fees, especially since the government was illegal? Thank you, Robert. If Trump is going to file a claim like that, the best place to do that would probably be like in Florida. But generally not. I mean, this is gross misconduct. I think the entire thing was born out of corruption. But generally not, right? Like, let's say you get charged with a DUI, you go to trial, you win. You don't sue the government and get damages for that. It's like you just won. Sorry, you're out of pocket. Your costs, unless the government causes damage to you, unless they're injuring you like police brutality or whatever, but they've got qualified immunity, and that extends into them prosecuting and failing to prosecute bad cases. Voice of the People's here says, I'm going to be busy tomorrow until our show, so I will send this today. Don't forget that K Bean speaks with us on Thursday on the Off Label podcast, and so make sure you're checking out that channel and listening to our very own K Bean. We got Ken L. says, hey, 28 U.S. Code 543 defines special attorney as assistant U.S. attorney, meaning working under one. 541 defines U.S. attorney, and 542 defines assistant U.S. attorneys. And the judge gave us some analysis on some of that, Ken L. And none of it applies to Jack Smith. What's up? Elf is bringing in 10 new membos. Elf, thanks for bringing in the 10 newest membos. Great to have them here. We got one old guy's opinions. Says, Judge Canon mushroom cloud Biden's DOJ and left shadows on the wall of Jack Smith, AG Merrick Judy Garland, and President Joey Biden. Yeah, they're all in hot water right now. Immunity and Jack Smith's unlawful. If they just easily could have just appointed a U.S. attorney. What would be so hard about that? Couldn't do it. Hey, what's up? Renee Anderson sent in a very nice dono. Thank you, Renee, for sending that in. Another one from one old guy's opinions says, Judge Cannon said Jack Smith has a big backside, like an elephant in a mouse hole. Yeah, something like that. Something like that for sure. Jack Smith. Does he have a big ass? I don't know. What's up? Chris Smith says, cry harder, Jack. With your wounded soul, let your tears heal and make you whole. Just cry it out, Jack. Just get it out. Just get it out. Hey, Cowboy Rob says, Rob, have you ever been going through one of these cases and had like a aha moment? I mean, like, OMG, I need to get in touch with someone. Like you've seen something they didn't. Yeah, I mean, there was that one time, it was actually during the Chauvin trial, where I actually commented on it live. And I think that point made its way into the testimony that afternoon. So we just kind of talk about it. Like we made up a point on the Derek Chauvin thing. I thought it was interesting. The point was that George Floyd was already complaining about not being able to breathe before he was on the ground. So when he was in the back of the patrol car, he was not able to breathe. Yeah, I can't breathe, I can't breathe. And then he landed on the ground, and I said something like that during the morning stream. I was like, you know, he says he can't breathe, like, cross-examine him on that. And then that made it into the afternoon's testimony. I don't know that I had anything to do with it, but it got a lot of attention on X, and then it made its way into the testimony. So stuff like that has happened, but that's about it. What's up, Cowboy Rob? Thanks for that. One Old Guy's Opinions says, has anyone seen the prediction of the incident on the 13th and the stopping of the lawfare? This is the name of the man who made the prediction, Brandon Briggs. It is eerie. I've not seen that one, but thanks for flagging it for us. The Wolfe Flock, what's up? Became a new YouTube member. Great to see you. Thanks for joining us, the Wolfe Flock. We appreciate our membos. Elf brought in 10 new membos. Thank you, Elf, for bringing the 10 new membos in. We got this one from Ty Cod. Says, thank you for your commentary and hot off the docket. I was going to wait till later, but it's fresh. And later, Trump's going to have a VP, and so we just got to get to business, man. We got to get to business. Hey, what's up, Just Rhonda? 10 membos coming in, man. So grateful for all the new membos. Very nice to see you. Thanks, Just Rhonda, for bringing 10 of them in. 10 new membos. Remember, Just Rhonda brought you in. We have this one from One Old Guy's Opinion. Says, what really angers me is that they really thought that they would get away with it. They were close, man, which is why I think they delayed the cases so long. Because they knew that if the appeals courts and the Supreme Court got involved, there was going to be problems. So they tried to indict and convict before the election so nobody could review it. But that didn't happen. They blew it. What's up? Thank you for that, One Old Guy's Opinions. Hey, Stan K. What's up, Stan? Says, if Jack Smith's appointment was illegal and invalid, does that mean that he doesn't have the immunity that a valid, legally appointed prosecutor would normally have? Could he be held personally liable? It's another great question, Stan. So in other words, piggybacking off that prior comment, could Trump sue the DOJ? Right? Is anybody liable for this? Well, if Jack Smith is not a lawfully appointed U.S. prosecutor, never was, why does he get qualified immunity? Because he was acting as a prosecutor? He was basically a fraud, right? This whole thing was a fraud. He never had any power from the very beginning. So a private citizen who's acting as a fraudulent person should be open to damages, right? The whole DOJ should. So the question is going to be whether Trump can get past that qualified immunity and whether hold them liable for it. Honestly, I'd love to see him try, but as a general rule, those claims fail. Just as a general rule, I mean, they do pass sometimes. There are special people who sue the government specifically, claiming damages and trying to recover losses, and it's a big practice area. But they're difficult cases, right? You don't just sue the government and recover millions of dollars. There's a lot of deadlines and timelines. You got to file a notice of claim and all these things. I certainly hope Trump investigates that. I'm sure his attorneys are right now. His attorneys are saying, okay, Todd Blanche and can we also say shout out to Todd Blanche and the team down there? They have done some amazing work. Yeah, so amazing work in Florida. So thanks, Dan. It's a great question. I'd like to see them pursue that. We have this one from Tara R. Says, Mary dismissal all. Mary dismiss all. We have this one. Praying for President Trump. Thank you, Tara. We're probably going to see him today, right? In this VP announcement, if it happens today. Is he teasing us? Do you think it's going to come tomorrow? Hey, what's up? Alex Jones is the only VP deepest fears more than Trump from JC. Well, yeah, I guess we'll see who the VP is. And then we'll see if they try to take Trump out again. Hypernova says, did you hear Morning Joe got canceled today? I did hear that. Yeah, they didn't let Joe on the air because he was probably having another meltdown again. Niels, Membo for 5 months, says, the International Criminal Court is in Netherlands. We don't want Jack Smith either. I don't blame you. Yeah, we don't want to dump him on you. We like our friends in the Netherlands, but where can we send Jack Smith? I don't know, to like France or something? Hey, what's up? Thanks for that, Niels. We got this one from Carlos Ventura. Thank you, Carlos. Thanks for sending this one in. No comment on it, but a very nice dono. We appreciate that one. Tara R. says, Crossfire Hurricane docs are incoming. A girl can dream. That'd be nice. To get to the bottom of the rigged attempt to sideline Trump. King Ginger's here. Says, Jack and Garland should have to pay us back. Yes. All that money should be recuperated from all the people who got paid. And I'm sure there was a ton of grift going on. Go recover it. Stolen funds. K Toady, what's up, K Toady? Became a YouTube membo. Great to see you. Brian R says, can Citizen Jack claim immunity from prosecution? I mean, I would think that he would claim that. He would say, I thought I was lawfully appointed. I was acting in good faith. We were following historical precedent. We were following the norm, right? And so the next question would be, can you breach his force field if he was acting as a special counsel? My argument would be he knew he wasn't a special counsel, and he continued to prosecute this. And in fact, Trump said, you're unlawful. And at that point, Jack should have known. So even if maybe Jack has an excuse from the inception, as soon as Trump raised the argument, then at that point, Jack was on notice. You're unlawful, buddy. So if you don't address that, or if you continue on this prosecution, you're liable for it, would be my argument. Sean W., what's up, Sean? Thanks for becoming a new membo in the house. Tomorrow VI says, hey, does an illegal appointed prosecutor have qualified immunity? No one's above the law, except maybe a prosecutor who was not ever really a prosecutor. Let me read in on that a little bit more. Because, yeah, normally prosecutors do, right? They get almost no trouble at all. Look at Fannie Willis. She funneled $700,000 to her lover. No repercussions basically at all thus far. She might still, the Court of Appeals might come down, but it has been allowed to continue on. So prosecutors are above the law, all right? The government officials, they are above the law. They just keep telling us that no one's above the law, so it makes us feel better, but they are. What's up, Sean W? Sean W became a membo, and Jack Mack says, Jack is whack. Totally. And he lost again. He's a terrible attorney, too. Hey, Count Drago says, BlackRock ad just pulled featuring the shooter. Great news on the Jack Smith case. Also, do you think there was a mole or moles in the Secret Service? Probably. Yeah, I mean, it's a big, giant agency, so I would imagine that, yeah. I think it's what's more likely, that every single person in the Secret Service is on the up and up, or actually, I know this is not true because there was one Secret Service agent who we read about yesterday, I think, who was fired. Remember, fired for saying, I wouldn't take a bullet. And you say, well, that's weird. All right, so would she work with, Democrats or somebody else? Maybe she's already working with them. So awesome. Thank you for those amazing comments, my friends. All the beautiful donos on this very busy day. Oh my goodness. And so let's poke around and let's see what's happening on X, and then we'll say hello to our friends on Locals here. As soon as we wrap it up, we are going to go over to Locals and debrief for a little bit. And I'm not real sure what the plan is on the rest of the day. It's going to kind of depend on what happens. Lindsey Graham is out, says, Judge Cannon's decision is right on the law and it makes sense to me. Says, Attorney General Garland relied on this incredibly broad statute to appoint the special counsel. Judge Cannon was right to restrict the application, and her decision will also impact Jack Smith's actions beyond the classified documents case, including the J6 case. Special counsels with sweeping authority should not be the norm, but I'm sure this matter will be appealed by the Biden DOJ. I'm sure it will. The big picture, there will be no consequences for Hillary and her team deleting emails, destroying hard drives with a hammer, or President Biden storing classified materials at his home or elsewhere. Selective prosecution has always been of great concern for many Americans. This is a good day for the rule of law. And so, latest from Fox, seeing if Jack Smith has responded to any of this. Doesn't look like we've heard from the DOJ yet. I'm sure that they will be appealing this in due time, but do not have that yet. So, okay, so I was not sharing the screen on that one. My apologies. But, all right. So, my friends, let's say hello to our friends on X. Let's see what's happening there. And then we'll call it a day and go on over to Locals. And we're going to keep our eye on the RNC, keep our eye on the VP stuff, and see what is happening as the day continues to unfold. All right, so let me get my screen resituated here, and we're going to share and say hello to our friends on X. What's going on, friends on X? All right. So let's get this puppy queued up and see who's over there. We've got Jim. What's up, Jim? James Pepper's in the house. Hey, WEC News says, I love these podcasts. When I get some discretionary income, I'm joining on Locals. Amazing. What's up, Right to Jack? Base and Bias is in the house. Shane Williams. says, Rob, brother, you're killing me. I'm at work. I enjoy catching these live. What's up, Watching the Watchers fam? I'll catch this later tonight. Thanks for the breakdown. We had to hit it, man. It's fresh. We love it when it's fresh out of the oven. Rob says, impeach Mayorkas, impeach Garland, impeach Biden. Silence Dogood says, you realize that this decision was made before today and took time to craft and write. Timing of what happened on Saturday is now making sense. Someone got wind last week that this decision was coming. Interesting. Hey, the other side of the mountain says they huffed and they puffed and Lady Justice blew their house down. P.S. I'd be on Rumble, except I've not been able to see or post in your chat. Don't know why. Well, it wouldn't have been anything I did, other side of the mountain. Good to see you, Pamela. David G. says, close the J6 and open the J13 committee. That's an interesting comment. Close the J6 committee, open the J13 committee. So, very good stuff. MLB Davies says, how does that impact Walt Nada? And they need to pay that money back, stat. Well, if Trump's case is dismissed, I mean, Walt's case was basically a derivative of Trump's. And I think she said it was all of them, right? I think it was all the co-defendants. Yeah, all the co-defendants are listed on the order dismissing. So the entire case should be gone for all of them because Jack Smith was prosecuting all of it. Whew, good day. Very good day. Okay, so my friends, that is what we have cooking over on X. Very grateful to our friends on X for joining us. We got Debbie Marie who came by, says, thanks for the explanation as always. Thank you, Debbie. Thanks for being a member for 7 full months, almost 2 more, till we got a new baby in the house. And Daryl became a YouTube member. Thank you, Daryl. And so very grateful for you becoming a member. And it's going to be a busy day, my friend. So the RNC is cooking right now. Let's see if we have an RNC schedule here. I know there's a lot in change. So here's a full schedule for the RNC convention. Here's what we've got cooking. And then we'll send you over there and then we'll see what unfolds on the day. Here is the schedule. 12:45, noon to 1:30. How AI affects women in democracy. FISER Forum, 12:45 to 4:45. 2 to 5:30, there's going to be a convention fest. There's going to be a lawyer's reception. Veteran candidate mixers, receptions. Then there's official session 2 at 5:45 to 10. So don't really know if there's a lineup on who's speaking or what. But that's happening all day today, my friends. And so seems like we're going to get a Trump vice presidential pick today. But sometimes I feel like Trump kind of teases us a little bit. So is it going to come today? Is it going to come tomorrow? Is everybody going to be playing, waiting for an announcement? Time will tell. Who knows? All right, let's say hello to our friends on Locals. Of course, we are going to go over there for our members only after party, but we had some amazing donos that came in. And let's say hello to our Locals dono friends. We had several of these. John McGarvey says, Rob, I'm working, so I need you to read this document very slowly and softly so I can sit down and listen while smoking a cigar and sipping a bourbon. Sounds like a nice way to listen to a court document, I'll tell you that, John. Appreciate you being here on that one. Jester Bob says, 47 for Trump. Thank you, Lord, for allowing him to survive such a cowardly act. Amen to that, Jester Bob. The Rubos, you know them from RubosSaltShop.com. Here's what they posted for us. They said this, good morning and good afternoon, Robin Watchers. Praise God, President Trump is vindicated and exonerated. We love the Rubos. They wrote, 2 words came to me while I was in prayer on May 28, 2024. The Holy Spirit said to me, vindication and exoneration. The definition of vindicate is to clear, as from an accusation, imputation, suspicion, or the like, i.e. to vindicate someone's honor. And the definition of exonerate is to clear, as of an accusation, free from guilt or blame, i.e. he was exonerated from the accusation of cheating. And a great comment from the Rubos. Vindicated and exonerated. Amen to that, the Rubos. This old guy says, you know, I can get Jack Smith on a flight back to The Hague as quickly as Wednesday, 10:25 p.m. for only $1,300. That's pretty cheap, this old guy. You know, I'm down for that. I'll throw in on that. Easy. Yeah, so if we can get Jack Smith to agree to get the hell out of this country, I'm down. I'll chip in on that. Thank you, this old guy, for starting it. We had Sandy say, if Smith appeals all the way to SCOTUS, is Thomas recused from hearing due to already stating an opinion on the case, not before him at the time? No, I don't think so at all. If yes, he doesn't plan to be on the bench when the case comes. Is there an open seat coming? No, I don't think so. I mean, you would recuse yourself from something you have a conflict on, but they comment on cases all the time, right? No, this is a legal issue, and I'm commenting on this. It comes back up. As I said, this is why this is wrong. So I think it's perfectly appropriate for him to stick around. Hey, don't tread on me. This is a good one. I thought it was closer to this location, though, wasn't it? Don't tread on me. It felt like the bullet was here. Although this is great. Yeah, this is great. Hey, Glocky's here. Trump indicted for inciting assassination attempt. Yeah. It's a funny one. It's a funny one. Every time Trump speaks, there's either an insurrection or he gets almost assassinated. So that's how bad he is. Trump. Insurrection or assassination, no matter what he says. Hope for Trump is such an iconic picture. And yeah, the poll does look like it's holding that flag up. It's like Iwo Jima. It's wild. Hey, what's up? Yeah, from Glocky, this one, Boston Globe, CNN, Clinton Machine, all pointing guns at him, and he just keeps surviving. Hey, Glocky shared this one. This is a funny one. Did you hear about this 2025 project? Listen to this. It's absolutely insane. You may have heard of it, but you didn't realize how horrible it was. Arby's 5 for $5 returns. $5 footlongs back at Subway. Oh, my God. I remember those days. Ashtrays in Burger King. McRib year-round. Dine-in Pizza Huts with red cups. Ugh, I miss them. Marlboro Point catalog returns. Pull tab beer cans. Smoking and real food on planes. CD players back in cars. Blockbuster reopens nationwide. Cocaine back in Coca-Cola. Hunter's happy. No fat chicks in the Sports Illustrated swimsuit issue. Finally. Middle car seat with no seat belts. And a federal bailout for Red Lobster. God bless America. Let's make America great again. Jack Mack says, hot damn, you got audible joy out of me on this. If anyone gets this opportunity, please let our Trumpster know that I am not tired of winning yet. No, we're not tired. In fact, I feel great. I'm ready for some more winning, baby. I'm with you, Jack. Let's go. Here's one. I don't know what this one is. A Barbie meme. Leanne says, hey, thanks for having a show after the Trump debacle. We needed a bit of grounding and hugs. Good to see you, Leanne. Yeah. This was a good one. A very good day. What? Wild. Okay. Jack Smith has a history, says this old guy, of playing fast and loose with the law. It's so satisfying to hear a judge exercise their command of English language and the law in such a devastating rebuke of a pretender like Jack Smith. It was great. It was thorough and complete. Chutkin's going to have a bad day responding to it. Hey, what's up, ELZ? Do we have a running list of Trump's legal charges, status, and outcomes? Looks like a job for a spreadsheet. Yeah, I mean, and the charges, I don't have all the charges delineated, but they're all basically on hold. New York case is on hold, pending sentencing because the judge wants to deal with immunity. Fannie's case is also on appeal, pending disqualification. Florida case just got dismissed. J6 case is coming back down for immunity decisions based on the SCOTUS ruling. E. Jean Carroll case is being appealed, which is the grabbed by the Bergdorf tape thing case. So that's pretty much it. There's a lot of other civil cases, but those are the big ones. Rocky says, happy Monday. Mint coverage over the weekend, by the way. Appreciated. Thanks, Rocky. Thanks for saying that, man. It was a busy weekend. My goodness. What a couple of days those were. Hey, what's up? ELZ says Judge Eileen Canon, defender of the Constitution. And SoCal sent this one in. Fight, fight, fight. God bless the USA. Glocky shared this one talking about a black female governor, if that happens in Georgia. Woodchip Bill says all the angst caused by those charges has resulted in a happy resolution. It's so nice that the Constitution is finally being followed by Judge Canon and SCOTUS. I finally feel some more hope for the USA. Glocky says, notice how no one has leaked the Veep yet? It seems Trump has learned who to surround himself with and who to trust. Jack Mack is here. Thank you, Jack. Says, outstanding rundown, Rob. Wanted Tulsi Gabbard as VP, but that's pretty much a lost cause. Side note, I really like that polo. Great colors. Oh, thank you for this. Yeah, it's got some nice, it's nice little blue. Nice little, I like them. Hey, thank you for that. It says, final thoughts. Keep those folks that took a bullet or lost their lives this weekend at the forefront of your minds. They are martyrs for our cause. This is a cause. I agree we are on the right side of history. Stand firm, watchers, and press forward. Amen to that, Jack. You're right, we are. And I think that their own these people are acting dishonestly and selfishly and in opposition to the law and into opposition of justice. And you can only hide that for so long. Like raw power can only hide that for so long. And they're starting to watch it evaporate real quickly. And as soon as like the facade starts to evaporate, right, as soon as Joe Biden becomes known as a demented president, it's weird how the wheels come off so quickly. Because the facade of legitimacy has crumbled. And it's very important to have that legitimacy. It's necessary to a functioning country. NY says, Smith can be prosecuted, and in fact, Judge Cannon's ruling would deny him qualified immunity because he was not a legal office holder. Uh-oh, Jack. U.S. Code 242, the provision makes it a crime for someone acting under color of law to willfully deprive a person of a right or privilege protected by the Constitution. It's not necessary that the offense was motivated by racial bias or animus. So could Trump sue him under U.S. Code Section 1983? He could. The question is he going to win? Sandy says, this SCOTUS case gives Trump authority to sue for malicious prosecution, especially on the D.C. case with two 15C2 charges. Yeah, maybe he will do that. Yeah, maybe he will. I hope he does. Yo, it's breaking. RFK is meeting with Trump over the Veep slot. Wild. Charlie B says, if this is appealed, where does it go? It goes to the 11th Circuit. And then up to the Court of Appeals. And I think there'll be a circuit split because Chutkan will find differently. Chutkan's going to have a hard time keeping that case around. Hey, Sandra Beasley, Viva's at the RNC. You're kidding. Viva's over there? How cool is that? Beth says, I appreciate you so much and look forward to listening to your analogies. You make a lot of sense in all this confusion. You had me at a Rittenhouse. That was a wild time, too. Yeah, the Rittenhouse case. What a moment that was. Hey, Jack Mack says, the U.S. government did this deliberately. They should pay the legal expenses, not organic costs, that they were incurred due to illegal activity. They shouldn't get away with it. Corrupt crapheads. Jack is whack. Jack Smith is whack, no doubt, Jack. Hey, what's up? Tobo says, it appears to me, from the thoroughness of her opinion, Judge Cannon should intimidate both Jack Smith and Judge Chutkan from following through with the J6 case. Well, that's a great point, Tobo, and Chutkan's in that bind right now. She's got two things that are going to push her to dismiss this case: immunity and appointment, and appropriations. Now, really three things. So Garland should resign. He won't, because he's been unfaithful to the Constitution and the law. He has thrown so much responsibility out, which is a problem. Bonnie says, thank you for explaining this document. You're the best. I read it but failed to comprehend all of it. It's obvious she put a lot of research into her work. She did her due diligence in writing this. She did the right thing. Now, how will this play on the J6 case? Any predictions? Yeah, I think that Chutkan might use the immunity decision to... Chutkan's going to want to avoid a circuit split. And she's going to want to keep the case. So she's in hot water. I think she's, probably going to try to write an opposite opinion from Canon and say Jack Smith is lawful. If that's the case, then we have a DC and 11th Circuit split. We have a problem now because she says this regulatory framework is appropriate, and Canon says it's not. So then the only people who can decide that will be SCOTUS. So the J6 case, I think, will ultimately be dismissed. It might be on immunity or it might be on appropriations, but it's not going to trial before the election either way. Here's one from It's Jake from Oxford. He says, okay, Rob, look, I pulled some strings for you and I got the transcripts for the phone call between Biden and Trump. I only do this for my show, which this show is Jake Sullivan's show. So don't spread these around. Did you know that Senator Cruz has a podcast? He does. Definitely don't want Ted Cruz getting this. So apparently here's a call. On the record transcribed phone call between Biden and Trump. Oh, I see what this is. Okay, we'll let that be read in the after party. We got Chuck Holzer says, any particular reason why Canon chose this particular reason to dismiss over others? She had a few to choose from: tampering, selective prosecution, others. Was this just the quickest way to depose or dismiss the case? She had Thomas's opinion to assist her. Did she think it was the most solid case to dismiss? I'm sure she figured out she'd be challenged on appeal and figured this would ultimately postpone the case until after the election and ultimately end up back at SCOTUS. Yeah, I think she probably just thought this was the strongest issue. I mean, I think it's probably simple as that. Just thought it was strong and hung her hat on that one. What's the 11th Circuit going to do, says Elliot. In December, they ruled that the removal of the federal court is not available for former federal officers. Chief Justice of the Circuit wrote that. Canon treats the following line in Nixon as dictum and thus not binding on the lower court. And so some more analysis from our friend Elliot. Rocky says, was joining late, still got to run through the ruling, but man, I'll take the W. Smells to me off of, once again, a weak ruling. There were more egregious reasons to dismiss this case long ago, but she falls on the most bureaucratic technical reason instead of executive privilege or abuse of power or targeted prosecution. Again, I'll take the win, but I'm tired of waiting for the door to be slammed shut once and for all on all these cases. Guess we'll see what the appeals court says. And still get my first cup of coffee from Rocky Water. Yeah, I think it's a good win because it makes everything go. It makes everything go bye-bye. And it can also apply to the J6 case. The other things may not have also applied to the J6 case. If it was only abuse of power, then Jack could have said it was only on this case. If it was executive privilege, only on this case. But this really delegitimizes Jack through and through. Jeremy says, and hopefully you had your coffee, Rocky. It's a beautiful Monday. We got Jeremy says, Judge Cannon's ruling this morning got me thinking about the true nature of the justice system I have constantly to remind myself of. Although the justice system typically appears to use logic and reasoning, rulings and dispositions are not confined to those. In Florida, a judge can make a ruling based on the Constitution and laws, and a judge in a different state can do something different. My point is that a judge can decide to accept the prosecutor's argument that 35 times 0 is 34. I'm a computer scientist, and my logical brain breaks every time I see anything that breaks the laws of physics and logics coming out of the justice system. I suppose one could argue that if you constantly fail college physics and math classes, you might be better suited for the law. Funny. Right T says, the courts are usually so fast to use other courts' decisions as justification for their own, but the J6 judge won't do that here. Weird. I wonder why. Elliot, our doc master, has got the doc for you if you want to download that one. Kansas Hillbilly says it's about time. Now let's see what the far leftist is up to in D.C. and what they do. Good to see you, Miss Lucky. And my friends, we of course are going to go over and hang out with our Locals friends for a little bit longer, but that's what it looks like on Locals. Great comments, great people, and a lot of fun. Hey, third cup of coffee, feeling better. That's good. Hey, what's up? And it's a beautiful day. So, all right, my friends. So we are going to leave it there. Now, we're going to keep our eye on what's happening elsewhere throughout the day. And so we may be back later with another live stream, depending on what happens on the day. Time will tell. But it's a beautiful Monday. I hope you're making it a great and beautiful day. We are going to leave it right there for the time being and head on over to watchingthewatchers.locals.com. We're going to chat for a little bit. See what else is cooking. RNC's happening right now. We're keeping our eye on the Trump VP selection. And I'm sure we'll have some more assassination fallouts as the time develops. But it's a beautiful Monday, my friends. I hope you're out there getting after it, making it a great day. There's a ton of news that's percolating. And so it's always an honor to spend that time here with you to go through it and parse it all. We will be back here later. I don't know when exactly. So thanks for subscribing. Thanks for hitting that notification bell. We are going over to Locals to debrief. And so I hope to see you there. But if not, we will be back here later to get into it again. And in order to do that, we're going to need to see you so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful day, a beautiful Monday, my friends. I'll see you back here soon. Until then, be well, and bye-bye.